I'm Sally Ryder, and on behalf of the Rehnquist Center, I'd like to welcome you all here to our annual Constitution Day program. The Rehnquist Center has sponsored this program since 2008, but the college, under the leadership of former Dean Tony Massaro, has held this program for many, many years. I'm going to introduce our panelists very briefly. When I worked in Washington, they always said to leave for the introduction the more important person, so I'll keep it brief. Sitting next to me is our own Professor Dave Marcus. He's taught at Arizona Law since 2006, specializing in civil procedure. Received his JD from Yale Law School. In fact, he has a classmate sitting 2 seats down. And then he clerked for Judge Willie Fletcher on the Ninth Circuit Court of Appeals. Professor Marcus has been selected Professor of the Year here at Arizona Law twice in his brief teaching career. And just last year, when he was visiting at Yale, was also selected Professor of the Year. And I think when you hear him summarize the cases today, you'll understand why. Next is Judge Neil Wake, who is a native of Phoenix and serves on the U.S. District Court for the District of Arizona. Prior to being appointed to the bench, Judge Wake was in private practice in Phoenix. He specialized in commercial, administrative, constitutional, and Indian law, and did about 40% of his time as an appellate lawyer. And I'm going to just summarize my favorite Judge Wake story, which is on his first day of practice as a young lawyer, the very first case he was assigned, 5.5 years later, he was arguing that case before the U.S. Supreme Court and won. Melissa Murray has taught at Berkeley Law School since 2006 in the areas of family law, criminal law, and constitutional law. She's, as I said, a graduate of Yale Law School. And prior to teaching, she clerked for 2 judges, including then Judge Sonia Sotomayor on the Second Circuit Court of Appeals. And on the end is Clint Bullock, who is the Vice President for Litigation at the Goldwater Institute in Phoenix. Mr. Bullock has litigated and won cases in courts across the country, including in the Arizona Supreme Court and in the Supreme Court of the United States. And among other things, he's focused on defending school choice and property rights. So without further ado, I turn it over to our own Professor Marcus.
Thanks very much to Sally Ryder for putting together today's event. This is one of my favorite days of the year. I've been involved with Constitution Day now for several years, and I always learn a great deal from our distinguished guests. It's really a wonderful moment to celebrate the United States Constitution. My job as the moderator is to make the panelists look good. That is not a difficult job. Judge Wake is my favorite Arizona judge. To give you a sense of how I see myself as compared to Judge Wake, I spent the summer writing an article about one of Judge Wake's cases and the way that he managed it. So if that suggests anything, well, maybe poor topic selection on my part. I don't think so. I don't think so. If there is a more thoughtful, careful, and intelligent steward of civil litigation in the United States, I'm not sure who it is. Melissa Murray is one of my law school classmates. I knew at the time that she was going to be a rising star. Her star is not just it's rising, but it's already risen. I don't quite know where it fits in the galaxy, except very, very much at the top. I've watched her career unfold with a great deal of admiration. She's truly one of the finest minds in the American Legal Academy. And then Clint Bullock, I'm just staggered by his accomplishments as a litigator. The American Lawyer dubbed him once one of 3 lawyers of the year. This is the American lawyer, it's not the Arizona attorney or the Maricopa County, whatever. It's America. There's a lot of lawyers in America. He also was dubbed one of the 90 greatest Washington lawyers of the last 30 years. There are a lot of lawyers in Washington too, so it's really wonderful to have him here as well.
David, can I do a quick counterpoint on that? One of the other 3 lawyers of the year I was chosen was Elliot Spetzer. The star is
My father always says that the practice of law, you're nothing more than a taxi driver. You pick them up and drop them off. There's nothing about morals or the like that has to do with the law. So that's my father. This past term was truly remarkable. I don't know if I've ever had quite the experience that I did on the last day of the term in June, hitting refresh on my browser quite as often as I did. I'm sure many of you were in my position wondering what the court would do with cases that held the potential to truly transform the American social fabric. This follows upon a term that was likewise remarkable. The Roberts Court has shown a penchant in recent years for tackling some of the most protracted and difficult issues of social and economic policy. It was hard to pick cases to summarize this year to discuss. I'm hopeful that the four that we will talk about will impress upon you the incredible significance of the United States Supreme Court's willingness to engage with these incredibly difficult and profound issues. The first case that we'll talk about is American Express versus Italian Colors Restaurant. We are now 8 years into the Roberts Court era. Is it possible to predict what the legacy of the court will be? On the great questions of constitutional law, I don't think so. The chief seems to be a savvy operator. Just when he zigs, when you're thinking he's about to zig, he then starts to zag. If you think about his Obamacare decision of last term, I think that makes the point. But there is one direction that the chief is pursuing unambiguously, and if I may be a bit melodramatic, without pity. The Roberts Court has been labeled pro-business since the conclusion of its very first term, and by now the evidence of this inclination is all but irrefutable. According to the Washington Legal Foundation, a free enterprise legal think tank, business interests won 21 cases and lost 7 this past term. The United States Chamber of Commerce has seen its win rate rise from 43% in the early 1980s to 56% for the decade ending in 2005, to a whopping 69% during the Roberts Court era. Indeed, the court has become has started to offer somewhat of a concierge service to the Chamber of Commerce. Whereas the court only grants 1% of its cert petitions overall, it grants 32% of the cert petitions that involve the Chamber. To business interests, there's no front in the war against regulation of all kinds that has seemed more important than the class action front. As the head of the Chamber's litigation division said this past June, class actions, quote, are really where a lot of our focus and resources are going right now. If restricting the class action is the most important issue to the Chamber and its business allies, then they should get down on their proverbial corporate knees, gouty from all the heavy lunches they eat, raise their proverbial piggy overstuffed hands to the air, cast their proverbial eyes skyward and shout hallelujah. For the Roberts Court has given wealthy business interests a get out of class action jail free card in the form of the American Express opinion. Amex heralds the near demise of the class action, which in turn marks the dawn of a new era of effective immunity for a great deal of corporate misconduct. Why does the class action so rankle business interests? The class action enables plaintiffs' lawyers to bring huge lawsuits on behalf of people whose injuries aren't large enough to incentivize them to sue on their own. As Judge Posner once put it, only a lunatic or a fanatic sues for $30. But if 10,000 $30 claims can be aggregated together and the amount at stake is $3 million, then maybe you might find a plaintiff's lawyer who might be willing to take the case. To its supporters, class actions have two purposes. First, they perform a compensatory function. Class actions enable people who lack economic incentive to sue on their own to recover damages. Second, class actions perform a regulatory function. Prospective defendants get threatened with class action liability, so the theory goes, will then be deterred from misconduct going forward. After decades of fulminating against class actions, business interests in recent years have identified a silver bullet. Think about the terms and conditions you agree to when you buy a song from iTunes or you agree to a cell phone plan. These are consumer form contracts that no one but a lunatic or a fanatic would ever read. A few years ago, some smart young lawyer in some general counsel's office somewhere had a great idea. He thought, hey, why don't we include a class action waiver in these terms and conditions? Something like the purchaser agrees not to join or initiate any class action in any court. The problem is that irascible, stubborn judges like Judge Wake refuse to enforce these conditions because they don't like to have procedure dictated to them. They all think they're experts on procedure, and they don't want some private parties dictating the procedure to them. So then an even smarter young lawyer in another general's counsel's office had a different idea. Hey, what if we couple one of these class action waivers with an arbitration clause?
We'll get away from those pesky, irascible, stubborn federal judges like Judge Wake if we can privatize dispute resolution by sending a dispute to arbitration. Why can't we then customize the procedure to be applied in this private forum? This smart young lawyer realized that the Federal Arbitration Act gave her client a pretty solid legal basis to argue for the enforcement of these class action waivers that are coupled with arbitration clauses. Section 2 of the Federal Arbitration Act provides that an arbitration clause in a contract, quote, shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. Unless a plaintiff trying to proceed in court can invoke one of two exceptions, then the arbitration clause with that class action waiver is enforceable. The first exception was an unconscionability defense to enforcement. It ran into the Supreme Court's buzzsaw in a case called Concepcion, decided in 2011. Under California law, a contractual provision that purported to waive a plaintiff's right to join or initiate a class action or a class arbitration was unconscionable. The rationale for this doctrine was that without the class action, claims for $30 wouldn't get litigated, and the defendant would not be deterred by the realistic threat of litigation. The law wouldn't get enforced. This California unconscionability defense was rooted in an effort to preserve the class action's regulatory function. The Supreme Court held that the arbitration clause with the class action waiver was enforceable even if the enforcement of the clause meant that the law doesn't get enforced. This just simply didn't matter. Concepcion basically means that parties can defeat the regulatory function of the class action by private contract. The second exception to the Federal Arbitration Act involves a claim about the effective vindication of federal statutory rights. Under Supreme Court precedent, arbitration clauses are not enforceable if they prevent the effective vindication of a federal statutory right. So if, for example, the fees for initiating arbitration are so steep that they interfere with the ability of a plaintiff to bring an antitrust claim or a Environmental Protection Act claim or something like that, then the arbitration clause is not enforceable. The arbitration clause in the Concepcion case was very consumer friendly. There were all sorts of incentives that AT&T had added in to ensure that any person who discovered her injury and bothered to initiate the arbitration would recover something. The arbitration clause at issue in the Amex case, in contrast, was quite the opposite. The case involved allegations of antitrust violations against American Express. The facts of the alleged anti-competitive activity are not that important for our purposes. What was important were the following circumstances. First, American Express's arbitration clause and class action waiver were the opposite of AT&T's. There was no agreement to pay the plaintiff's costs. There was no agreement to guarantee some minimum recovery if arbitration was commenced and so forth. Second, each victim of American Express's monopolistic behavior could recover a maximum of about $50,000. So the maximum recovery was about $50,000. That's after accounting for the treble damages provided for by the antitrust statutes. Third, the plaintiffs put on evidence to establish that in order to prove American Express's anti-competitive conduct, they would have to hire expert economists whose fees would amount to hundreds of thousands of dollars at a minimum. The enforcement of the arbitration clause in the class action waiver, the plaintiffs argued, effectively prevented them from vindicating their rights under the Sherman and Clayton Acts. If plaintiffs couldn't join together, then the cost of litigating any individual claim, the expert witness costs, so significantly outweighed the extent of any possible recovery that no rational plaintiff would bother bringing a lawsuit. That there would be no way to vindicate one's rights under the antitrust statutes. Justice Scalia wrote for the 5-justice majority that voted to enforce the clause. I can boil down Justice Scalia's legal reasoning to 3 words: too darn bad. There's actually not a lot of legal reasoning in the opinion. That's something that strikes me as similar among all the cases today. Justice Scalia first noted that neither the Sherman Act nor the Clayton Act makes any mention of class actions. If Congress meant to guarantee antitrust litigants a right to join a class action, then Congress should have said so. Of course, the Sherman Act, enacted in 1890, and the Clayton Act from 1915 were both passed well before the creation of the modern class action in 1966. And it's also true that when Congress updated the antitrust laws in the 1970s, There's just reams of evidence in the legislative histories that Congress intended antitrust rights to be vindicated in class actions. But none of this matters. The statute doesn't explicitly say anything about class actions, so there you go. Second, Justice Scalia tackled the vindication of rights exception head-on. Justice Scalia insisted that the exception exists to ensure that a party to a contract does not waive its right to pursue statutory remedies. But the class action waiver doesn't qualify. To quote the justice, the fact that it is not worth the expense involved in proving a statutory remedy does not constitute the elimination of the right to pursue the remedy. Only a crazy person would bring a lawsuit, would spend $100,000 to win $50,000. But by Justice Scalia's logic, because the arbitration clause does not deny a crazy person this option, because it formally leaves this crazy person able to pursue its crazy remedies, the vindication of rights exception doesn't apply. Concepcion, the earlier Arbitration Act case, enabled companies to defeat the regulatory function of the class action with arbitration clauses and class action waivers in consumer form contracts. Amex does the same for the compensatory function. There are some rump areas of class action practice that remain unaffected by these Arbitration Act decisions. Securities fraud litigation, for example. But for the most part, most prospective defendants should be able to anticipate in advance those transactions that could subject them to class action liability. All they need to do is stick a clause in the contract of sale that waives class actions and requires arbitration, and they've effectively immunized themselves for liability under the substantive law. Amex, to my mind, is nothing more than a license to steal from millions of people, provided that companies do so $30 at a time. Hallelujah indeed.
All right. Any mediocre lawyer can win a case with substantial justice on his side. Only an exceptionally talented lawyer can win a case in defiance of obvious substantial justice. So my hat off to the lawyers who won this case. In terms of the close legal analysis, I think the dissenting opinion not only has it, but has it brilliantly well said. But in defense of the court's majority, let me offer these comments. Well, what are the motivations here? What are the likely motivations? One seems to be a fear, I wouldn't necessarily say a fear of class actions, but a fear of abuses of class actions. And there are abuses in class actions, especially B3 classes for money damages. And there's probably here the Supreme Court's continuing love affair with arbitration and its unwillingness to set virtually any boundaries on arbitration agreements. So maybe those are the psychological explanations of part. And there is, I think, a legitimate concern with the problems in class actions in arbitration. And let's go back to what class actions are about. Rule 23 of the class action rule requires demanding judicial oversight and set standards to protect the rights of absentees and to give legitimate benefit to a defendant so they get the benefit of an adjudication that is in their favor, good against all the absentees. Arbitration is a different procedure. Arbitration procedure doesn't have those standards. It is usually abbreviated economical procedures that are agreed to by the parties, or sometimes it's basically the arbitrator has the authority to set procedures or fill out details of procedures. So instead of a careful judicial oversight for the protection of the rights of absentees, you have an agreed process much shorter that risks inaccuracy of decision making, but the payoff for that is economy, speed, and resolution. So I think arbitration and class actions are somewhat in conflict. The legitimacy of arbitration comes from consent. It is consent to the arbitration procedures and to the arbitration that validates the summary procedures and including summary and largely unsupervised procedures. We don't have those assurances if you're going to have class actions in arbitration. The feasibility of class adjudication in arbitration, to my mind, is problematic and is a legitimate source of concern by the court, if that is part of their concern. On the other hand, it is clear that one cannot explicitly use arbitration to contract out of liability, where it's otherwise beyond the power of parties to agree to forego substantive rights. My solution here is that an arbitration clause should not be able to exclude class adjudication unless it provides an effective alternate to it. Now, that's going beyond, one could say, perhaps beyond the Federal Arbitration Act. And where it is not possible to do an effective alternative procedure in arbitration, the consequence should be that the arbitration clause is invalid and unenforceable, so that the substantive right prevails and that the right of arbitration is to come up with another effective remedy. That's contrary to Supreme Court case law. Now, another problem that intersects here with arbitration, as the federal courts, the Supreme Court in particular, has been construing it, the arbitration clause have become an instrument of oppression by parties with economic power. They are usually contracts of adhesion with no bargaining power on one side. And when I was in practice, I negotiated contracts where we tailored arbitration clauses and we came up with what we wanted, and that's fine. But that still happens in sophisticated commercial transactions. But that's not the norm in consumer transactions, or even this American Express that's dealing with its customers who are sophisticated business people. So there is this oppression that happens with arbitration clauses that can be in inconvenient forms, sketchily laid out with high costs. The American Arbitration Association, their fees are too high. I stopped drafting AAA clauses, arbitration clauses into my contracts. I would adopt their procedures, and then we'd have our own process. Instead of paying $20,000 on day one for the filing fee and hourly rates for one or three arbitrators, we just made it up as we went for other transactions. Now, so there is this unwillingness on the part of the court to police what really is borderline oppression in arbitration clauses. Of course, respecting party autonomy is an important value in contract law. People should be able to make their own deals and have to live by them. But contract law has various tools to deal with limiting the oppressive power in contracts, like the doctrine of unconscionability at extremes, where you're dealing with unfair surprise or the use of discretionary powers in an oppressive way. Adverse construction of contract terms against the drafting party, the party with unilateral power, so-called plain meaning of contracts isn't really plain meaning anymore under the Corbin doctrine about contract interpretation, which most courts, including the Arizona courts, follow. Plain meaning is dependent on context. You can look into situations and you don't necessarily have a plain meaning where it leads to a surprising or onerous result, although it may look plain at first blush. All of those principles seem to not apply in interpreting arbitration clauses. They just take them at face value with oppressive results. So I would suggest that the Supreme Court is simply in the wrong track, that there is room in interpreting the statute in conjunction with other statutes. So you don't take the Federal Arbitration Act as an absolute that trumps all other statutory purposes and trumps the general notions that we have about contracts and interpretation of contracts. I went too long. Thank you.
So when you get your packet for Constitution Day and you're looking through it and you see United States versus Windsor and Hollingsworth versus Perry and Shelby County versus Holder, and then you get to American Express, and you're a little puzzled. All of the other cases, the three cases that I first mentioned, have clear social justice implications. These are the kinds of constitutional law cases that send people to law school, that fire up constituencies. American Express seems a little weak on that point. And when my husband saw this on my desk, he looked at American Express and said, "Oh, Dave Marcus picked that case." But I want to redeem American Express for a minute. If you care about the little guy, If you care about social justice and small business owners and individuals just going about their daily lives in America, you should care about this case because this is a big case for the little guy. Dave and I, as Sally mentioned, both went to Yale Law School. I think we had different civil procedure teachers, but they both wrote a single casebook that we all use. And their casebook emphasized that civil procedure was about procedural rules. But it wasn't just about procedure, about getting things through, about a process, but rather that there were substantive values that undergirded all of those rules. So if you're a civil procedure student right now, this is something you have to keep in mind. These rules are not just simply about pushing paper through courts, but rather about particular substantive values that we think are important and that we want to advance. Those values might be access to justice. It might be efficient processing of particular dispute and disposition of cases in a way that allows the individuals to have justice and to make sure that their claims are heard in an appropriate time frame. It might also be about conservation of resources, whether those are judicial resources, time spent by judges, or other kinds of resources. And when you're actually in the world of litigation, you'll understand how those values are vindicated every day. Most of you, if you're in your first year of law school, know by now that most lawsuits are not actually disposed of through trial. If we went to trial on every single law school, nothing would get done. We would have a backlog of lawsuits waiting for trial. Instead, we have this system of federal rules of civil procedure that allow us to resolve cases in lots of other ways, whether through motions to dismiss or on summary judgment or by sending them to settlement and alternative dispute resolution mechanisms. And all of those are intended to advance those substantive values, to give individuals a way to make sure that their claims are heard, that they are heard in an efficient manner, and that they are heard in a way that doesn't inappropriately and unduly burden the resources of the court system or of individuals in bringing those cases. When you look at American Express, there's a clash of values at the heart of this case. On the one hand, the Federal Arbitration Act is about advancing some of those values, using alternative dispute resolution and arbitration as a way to shunt off some kinds of cases into different forum where they can be resolved as opposed to having them proceed through the traditional court system. At the same time, you also have the interests of the individuals in making sure their claims are heard and that they have access to justice. This case is very difficult in that it seems as though the majority here has focused, perhaps in a pro-business way, on a particular set of values, the efficient disposition of disputes, and that arbitration itself is an appropriate forum for doing that, and that at all costs we ought to preserve arbitration as a way of doing that. On the other hand, the dissent raises another set of values that I think are also quite important. What does it mean to have access to justice? Do you have access to justice if, in fact, proving your case would require you to spend more than 3 times what you could actually recover in arbitration? Is that justice? Those, to me, seem to be the competing values. And for that reason, I think this is a more important case than you might expect to think about. This is a case where we are clearly facing 2 different sets of clashing values. And at the heart of it is, what is the role of the court system and these different models of adjudication and dispute resolution in resolving those particular issues? Another point that I want to make that is perhaps more historical, maybe a little more provocative, and maybe a little off base and kind of wacky. When I read the majority's opinion, one of the first things that pops into my head is a case that's not really about civil procedure at all, but a case about contract, and that's Lautner versus New York. If you're a constitutional law student, Lautner should be familiar to you, if not infamous. In 1905, the Supreme Court decided Lautner, and it was a challenge to the Bake Shop Act, which was an act passed by the New York legislature that mandated particular maximum hours for bakers. The New York legislature came to the view that bakers worked in seriously dangerous conditions. They breathed in flour, they worked in hot and sweaty and often infectious workplaces, and they believed that regulating the bake shops would be a way to ensure that public health needs would be served, that the bread would be healthy, that individual bakers would not be sick and would not be passing along their illnesses to consumers and whatnot. And so they mandated these maximum hours for bakers. A bake shop owner, Mr. Lautner, sued the state of New York, saying that the Bake Shop Act violated the freedom of contract. And particularly, it violated the freedom of contract because it imposed between the employer and the employee another layer of regulation that basically eviscerated their opportunity to bargain and haggle over the terms of employment. And that violated the Constitution. The U.S. Supreme Court agreed with Lautner in a stunning decision that eviscerated the Bake Shop Act, but also venerated this idea of liberty of contract, of freedom of contract. The court said that individual legislatures could not actually do this kind of thing. They couldn't sort of step in between the employer and the employee and make those kinds of decisions. That freedom of contract allowed the individuals to bargain between themselves and to come up with the terms of their employment. One of the things that has been criticized again and again about Lautner is sort of the tunnel vision of the question of contract. Freedom of contract is one of the hallmarks of a liberal legal system. The whole idea that individuals can bargain for the terms of their employment or whatever is a core value in our legal system. But one of the things that ignores is that there's a backdrop against which individuals actually do this bargaining and haggling. The employers in the Bake Shop Act obviously had more bargaining power than the employees and could name the terms of the employment in a way that the employees really had no opportunity to contest. If you contested, you just weren't hired, and that was the end of it. It's a similar kind of inattentiveness, I think, to background norms and rules shaping the power dynamic between American Express and the merchants that work with them in this particular set of issues that are presented in American Express. The majority's opinion thinks about arbitration solely as an issue of contract. If you've done this contract, if you've made this contract, you've had an opportunity to bargain, to haggle, to set the terms of engagement between the individuals. But that's not always the case. These contracts are often shrink-wrapped contracts. People sign. You do it all the time. If you are on iTunes, as Dave mentioned, or in any other capacity, when you unwrap software package, you signed a contract and perhaps signed away your rights to litigate any claims you might have against the manufacturer. We do those easily and without thinking about them. We also do them in a vacuum in which we don't really have an opportunity to think about what the power differential might be between ourselves and the person who's on the other side of that contract. And that's worth thinking about. I agree with the majority that arbitration is an important tool for making sure that cases are heard and disposed of, and it's an important alternative to litigation. But again, there are substantive values, and one of those substantive values that undergird procedure is this idea of access to justice. And we can't necessarily have access to justice if we aren't really thinking about what it means for individuals to sit down and to make these agreements or not, and what it means to have these cases proceed and to have other substantive rights cut off by the promotion of a particular ideal of contract. So I think there's a lot here in this case, perhaps more than has been given attention in the media. This is not one of the cases that's been talked about as much as some of the others, but perhaps it should be, because this is a big case about important values that undergird our entire legal system. And for that reason, I think they really deserve our attention going forward.
Well, I want to thank Melissa. I am now in your eternal debt because you have taken a case that I had absolutely no opinion on because I know nothing about the subject matter and brought it into the realm of constitutional law where I feel much more comfortable. So I actually have something to say now. I don't know anything about class actions, and I don't know anything about arbitration. The main exception to that being every year or so I get a check for $7.13 for something that I purchased and had completely forgotten about. And those checks always warm my heart because I know that some plaintiff's lawyer somewhere has just made millions and millions of dollars as a result of that. Because I knew nothing about this case, I was completely persuaded by the majority opinion and also completely persuaded by the dissenting opinion. But thanks to Melissa, I do agree that there are some background principles in this case that go to constitutional law principles, and I have a slightly different take on them. I do think that the court enforcing contracts, particularly where there is not a clear directive not to is absolutely essential to a free society. And I am a fan of the Lautner decision, not only because of its veneration of freedom of contract, but because it represented a period of time in which the courts vindicated what was one of the major goals of the Constitution, and that was to look at legislation and to examine whether there were special interest considerations behind that legislation that would take the legislation out of the realm of the state's legitimate police power and put it into the realm of special interest legislation, or what the framers called factions, that the framers of the Constitution sought so vigorously to safeguard. So the vindication of a contract in this particular case, I think it does have ramifications for the little guy, but I think that the ramifications are positive. We cannot have consumer goods that are accessible to people in our society if they are subject to massive class action lawsuits that add tremendous costs to doing business. These costs are not absorbed by rich people. They are passed along to you and I. When I look in my wallet, I see 5 credit cards, 2 of which I think I've had for years, and I don't think I've spent a single penny in fees other than the fees that they charge to businesses. This is essentially a business giving me the opportunity to borrow money, and I pay absolutely nothing for that. That's amazing. That is amazing. That is a huge advance for doing commercial transactions in our society. Guess what will happen if a company cannot require arbitration in these kinds of contexts? They are going to be hit with these lawsuits that do very little for the consumers and a great deal for the lawyers litigating them. And they add tremendous costs and obstacles to those of us who are consumers. That is not to say that this lawsuit was correctly decided. I still don't know whether the lawsuit was correctly decided, because the first time I read the words, any of the words of the Federal Arbitration Act, were when I read this decision. So I honestly don't know. But I do think that this is an opportunity for Congress to make explicit what was argued was implicit, to weigh the competing values, and to come up with a system that is actually intended rather than simply accidental.
So, Clint, if you believe in Lautner, then that would make you a constitutional Luddite, which we will call that a Lautnerite.
Oh, I forgot to mention, if someone were to have accused Scalia of being on the side of substantive due process in this case, he would have had a stroke and died. So,
And Perry would have been different.
yes, indeed.
It's taking every ounce of self-control that I have to keep from responding.
To be the moderator, huh?
Yeah, it's no fair.
Tough.
It's no fair at all. I'm happy to talk to anybody who wants about class action. After the program is over, tonight, 3 in the morning. If you'd like to examine any of the assertions previously made, I'd be happy to do so. But we can't do that now because we have the cases cases that do not require any kind of redemption to render them interesting on our plate. And the first of these is the United States versus Windsor. Each of the 3 constitutional cases we'll discuss today suffers from the square peg round hole problem, or is it round pegs? I don't know. Something square and something round. The square peg in each case is really a fundamental right, the right to marry or the right to vote. And each case involves a claim of discrimination. Thus, each case would seem on its surface to trigger, or at least implicate, the familiar tiers of scrutiny analysis for adjudging infringements. But this familiar tiers of scrutiny analysis would otherwise push the justices where I don't think they want to go. So in 2 of the cases, in Windsor and Shelby County, the majorities push the square peg of individual rights, fundamental rights, into the round hole of federalism. Both cases are untidy, arguably shockingly so, as a matter of constitutional doctrine. But they differ. Justice Kennedy's opinion for the court in Windsor, invalidating the Federal Defense of Marriage Act, or DOMA, is an exercise in judicial modesty, an attempt to slow down the inevitable march to marriage equality that he kickstarted with his 2003 opinion in Lawrence versus Texas. The Chief's doctrinal fabrication in Shelby County, by contrast, is, to my mind, a remarkable exercise in judicial immodesty. So let's start with Windsor, the more modest exercise in constitutional make-believe. After an unhappy stretch of life, masking her sexual orientation, Edith Windsor fell in love with Thea Spire in 1963. Spire proposed to Windsor in 1967, and the two women planned to marry just as soon as New York State, their home, legalized same-sex marriage. In 2007, with Spire losing a 30-year battle to multiple sclerosis, the two women traveled to Ontario, Canada, to get married before time ran out. Spire then died 2 years later. Under federal law, if a couple is validly married at the time of one spouse's death, the other spouse can inherit from the decedent without paying taxes on the inherited property. Typically, federal law looks to the law of the state to determine the validity of a marriage for estate tax purposes. In 2009, at the time of Spire's death, New York law recognized other jurisdictions' laws on same-sex marriage. So it would seem that Windsor would have no beef with the IRS. But that wasn't the case. There's one big exception to the usual rule in federal tax law. Section 3 of the Defense of Marriage Act. The statute amended the Federal Dictionary Act to define marriage as, quote, a legal union between one man and one woman. This definition of marriage affected the 1,100 or so federal laws that account for marital status in one way or another, including the estate law. There are a bunch of other laws, Social Security laws, immigration laws, Medicaid laws, laws regulating where the spouses of veterans can be buried, and so forth. Windsor, facing a $300,000 tax liability that she would not have to pay if she had been married to a man, sued the United States, asserting that DOMA violated constitutional principles of equal protection. Then something strange happened. The Obama administration notified Congress that it would not defend DOMA, Section 3, on the merits, even as it continued to enforce it. In other words, the administration agreed that DOMA, agreed with Windsor that DOMA is unconstitutional, but nonetheless said, pay us the money that you owe us. So a group from the United States House of Representatives, known as the Bipartisan Legal Advisory Group, known by its initials as BLAG, intervened to defend DOMA on the merits. The procedural history, who appealed what, did bar for blag, whatever it's called, who appealed, who had standing to argue what issue, who could petition for certiorari, all this stuff proved dizzyingly complex. And going into the argument, there was many believed that the court would dismiss for want of standing or jurisdiction. Our other same-sex marriage case included another procedural mess and was resolved on procedural grounds. So for the sake of variety, I don't want to get hung up on the way that the court solved this federal jurisdiction problem from hell. Basically, the court held that because the United States still faced an injury if it lost, that is the foregone $300,000, the United States, the case satisfied Article 3 requirements for standing, even if the United States welcomed the loss that it might indeed suffer. As a matter of prudential standing, the fact that BLAG, effectively defended DOMA, I'm trying here, guys, a few laughs here and there would be helpful, defended DOMA on the merits, mitigated any concerns about collusion between the plaintiff and the nominal defendant. So the court turned to the merits. Now, to a lay person, the issue seems simple. Did Edith Windsor have a constitutional right to marry Thea Spire? To my mind, Lawrence versus Texas, which I'll mention in a short while, makes the answer to this question all but inevitable. But the answer, which I think is compelled by Lawrence, yes, of course they did, is as daunting as it is also required. 38 states, at least at the time of the decision, prohibit same-sex marriage either in their state constitutions or by statute. To quote the great constitutional lawyer Jerry Seinfeld, a decision invalidating all of these laws in one case is an awfully big matzo ball. Justice Kennedy clearly did not want to swallow this big matzo ball. So he articulated the merits issue differently. Can the federal government refuse to recognize a marriage that a state recognizes as lawful for the purposes of the Internal Revenue Code? In so doing, Kennedy turned a case about a basic fundamental individual right into a federalism case. An attempt to fit the round peg of fundamental rights into the square hole of federalism, I believe, accounts, at least to a certain extent, for what I think is quite a doctrinal mess. Now, the most natural course for Kennedy to follow would have been an equal protection or a substantive due process course. The equal protection argument would have been something like this. By disfavoring same-sex marriages that state law recognizes equally with opposite-sex marriages, Congress has denied same-sex people the equal protection of the law. This is the argument that Windsor's lawyers made in their merits brief to the court, drawing upon the familiar tiers of scrutiny analysis. But there's a problem. The court will only strictly scrutinize laws that disfavor suspect classifications. And the court has refused to recognize a group, such as a racial group or a group based upon nationality, as a suspect classification since 1977. All other laws that discriminate based upon classifications are subjected, or I'm simplifying obviously, but are subjected to rational basis review, which as I, a lowly Civ Pro professor, understand it, goes something like this. The Supreme Court justices play beer pong until 3 in the morning. They sit around talking about it like in a freshman year of college bull session. And then at 5 in the morning, when they're just about to pass out, one of them says, I can think of a reason why Congress might pass this statute that's not based on animus. And then they say, okay, the law is fine. So that's rational basis review. But had the court, so the court could either, the litigants had this challenge of convincing a court that does not like suspect classifications to elevate gays and lesbians to a suspect classification. If the court had done so, if it had elevated gays and lesbians to a suspect classification to invalidate DOMA, then the dozens of state laws that prohibit same-sex marriage would be effectively nullified. That's the big matzo ball. Okay, so that's equal protection. The substantive due process course would have been the Lawrence versus Texas course. Lawrence versus Texas invalidated Texas's ban on same-sex sodomy as inconsistent with a fundamental right to intimate association, a liberty interest that the state cannot invade based upon moral disapprobation. It would be quite natural to extend Lawrence to protect the right to marry. Indeed, Kennedy's Lawrence opinion begins. It roots the right of intimate association in a case about the sanctity of the marital relationship. A case of, so it would have just been sort of completing the circle to circle back to same-sex marriage. But again, had Kennedy followed this course, he could not have cabined his decision to DOMA alone. So what Kennedy did was to mix together a teaspoon of substantive due process, a teaspoon of equal protection, and 2 teaspoons of federalism. He started with a teaspoon of substantive due process. Same-sex couples have a right to intimate association. He then mixed in the first teaspoon of federalism. Some states have chosen to further dignify or afford further protection and dignity to this right by permitting same-sex couples to marry. He then mixed in a teaspoon of equal protection. Congress has chosen to disfavor these state-sanctified marriages for no other reason than to injure same-sex people. Now, how do we know that this unequal treatment comes from animus? Here comes the second teaspoon of federalism. Because Congress almost always leaves the regulation of marriage to the states, the Supreme Court could scrutinize the DOMA fairly strictly to see what the real motivation for the legislation was. Congress's power to regulate marriage is minimal and circumscribed and only incidental to other powers like regulating immigration. This fact about Congress's limited powers enabled the court to look strictly into whether Congress had acted for some non-discriminatory basis or out of animus. And what the court concluded was that the unusual deviation from the normal ordering of regulatory power between states and the federal government was not for any purpose other than to disfavor same-sex couples. In a dissent, Justice Scalia fairly denounced Justice Kennedy's opinion as legal argle-bargle, which is my favorite new term in the Supreme Court's lexicon. I say fairly because Kennedy's odd recipe is, as far as I can tell, totally unmoored from any traditional way that courts review laws that restrict individual liberty or discriminate based upon classifications. Now, this, again, you should discount my opinion against the fact that I know absolutely nothing about what I'm talking about. To anyone who likes tidiness in constitutional doctrine, who likes constitutional law to be, well, law, then Kennedy's opinion is in fact a mess. This is the messiness that you get when you push square pegs into round holes. But it is also an exercise in judicial minimalism, for better or for worse. A plausible federalism injury gave the Supreme Court an out from swallowing the big matzo ball. It is the dignity that the state of New York chose to afford Edith Windsor's marriage that got DOMA in trouble, not the injury that DOMA worked to Windsor's fundamental right or the discriminatory treatment that it required per se. For same-sex couples in states like Arizona, which refuse to dignify their marital unions, Windsor promises no immediate aid. The federalism round hole that Kennedy forced this case into slows down the inevitable jurisprudential progress of the cause of same-sex marriage. This progress, though, is inevitable. For one thing, Lawrence makes clear that states cannot classify based on moral disapprobation. For another, Windsor makes clear that the court will no longer abide by its tiers of scrutiny analysis and bend over backwards to find a rational basis for discriminatory legislation that disfavors groups denied suspect class status. The opinion signals the court's willingness to judge the reality of legislative motivation without deference, and one need look no further than the trial record compiled by the opponents of same-sex marriage in the Hollingsworth case to see how difficult a time opponents of same-sex marriage will have, demonstrating that their laws are born of anything other than a disfavoring of same-sex couples. Kennedy's opinion gives states more time to equalize marriage rights on their own. Since the decision, at least 5 states have introduced legislation to equalize marriage rights. I don't think it gives states much more time.
Okay. So Windsor's a case, Windsor and Perry together are cases that I've thought a lot about. This isn't really sort of a coherent whole, but just an assortment of observations that I wanted to flag. Some of them prompted by Dave's own observations, which were fantastic. One, note the odd coalition here. Not really odd when you think about it. It's not surprising that the liberal wing of the court would strike down the Defense of Marriage Act, but I think it is notable that Justice Kennedy, Justice Breyer, Justice Sotomayor, Justice Kagan, and Justice Ginsburg are all in agreement here. And I think it's Kennedy and Ginsburg together that really make clear what's at stake for the court here. Justice Ginsburg has been very clear in the past that she has been skeptical of Roe versus Wade, of the court sort of stepping in to ban criminal statutes that prohibited outright abortion throughout the United States. And one of the reasons why she has been skeptical of that decision is because, one, it's a substantive due process decision. She would ground it in equal protection. But more troublingly for her, the decision stopped what she saw as state-level progress on the issue. In her view, what was going on in 1973 when Roe versus Wade was decided is that states were incrementally deciding for themselves what they would do about criminal bans on abortion. And then this decision, authored by Justice Blackmun, comes along, sweeps everything off the table, and prompts a backlash. And actually, in the aftermath of Roe versus Wade, you find opportunities and access to abortion and abortion services sharply curtailed. And for Justice Ginsburg, that's a setback. Right? The backlash that Roe versus Wade prompted is a problem. And she's worried, again, that the court got too far ahead of public opinion on the abortion issue. And it's my view that that's one of the things that's animating her thinking in Windsor and Perry, that perhaps if the court steps in, does something sweeping, as some of the advocates suggested the court should do, the court will get too far out ahead of public opinion on this issue, prompt a backlash that actually sets back the progress of LGBT rights even more. So I think it's really interesting that you find this coalition. I think Dave is exactly right that what's going on here is Justice Kennedy driving a train that he put in motion 10 years ago in Lawrence versus Texas and stepping on the brake like this. Like, this is an attempt to slow this down. And I think to understand what's going on in Windsor, you really have to step back 10 years ago and think about what happened in Lawrence versus Texas. So if you aren't familiar with Lawrence versus Texas, let me explain. In 2003, the court faced a challenge to a Texas statute that prohibited same-sex sodomy. It was a criminal statute. The court struck down that statute on the ground that the states could not use the criminal law to impose some particular form of public morality without some clear showing of harm. there was no rational reason related to the prohibition that the state had in place. Critically, as soon as Lawrence was announced, gay rights groups stepped up and said, this is the first step. This is the opening salvo on the road to same-sex marriage, which was curious because Lawrence versus Texas was not remotely a case about marriage. John Geddes Lawrence and Tyrone Garner were not getting married. They were not long-term partners. The opinion talks about them as though they had gone to Crate and Barrel and used the little gun and registered for things. But in fact, it was a one-night stand. And according to Dale Carpenter at the University of Minnesota, when they were arrested for engaging in same-sex sodomy in John Geddes Lawrence's apartment, there was another man with a video camera, right? All right, let's leave that out there. Justice Kennedy, when he talks about John Geddes Lawrence and Tyrone Garner and Lawrence, crafts a picture of them that is stunning, not in judicial minimalism, but in judicial maximalism. I mean, he talks about them as though they are long-term partners living a life in common. Like they are 2 steps from going down to City Hall in the way he talks about them in that opinion. And I think it's important to recognize that. What Justice Kennedy is creating, protecting, and we're not sure how he's protecting it, it's not clear, it's a fundamental right, not clear what kind of right is at stake, but there's something that he believes is entitled to protection here. But it's a particular kind of relationship. And it's clear at the end of the opinion what kind of relationship he has in mind. Now, in responding to Justice Scalia, who says if you strike down this law on the ground that moral disapprobation isn't a valid use for state criminal law, what else might fall? Justice Kennedy responds to Scalia by saying there are lots of things that the criminal law might be used to restrict. This isn't a free-for-all of sexual liberty. You can still use the criminal law to regulate rape and domestic violence and statutory rape and public sex and a host of other things that remain indelibly criminal. But what's at stake here, as Justice Kennedy reminds his colleagues in Lawrence, is a relationship that is personal, that is private, that is intimate, that is between 2 people. And this is where he sort of talks about them as though they are sharing a life in common. It's a marriage-like relationship, even though factually it isn't. So I think that needs to be out there. Lawrence is offering up a particular kind of protection, but it's contingent and it's cabin, and it's not for everybody. Lawrence is not protecting bathhouse sex. Lawrence is not a full-throated endorsement of sexual liberty. It's an endorsement of a particular kind of relationship that's domestic, private, and intimate and marriage-like, even if it's not eligible for marriage. Then you have Windsor, 10 years later. And just as an observation, it's important to note, Edie Windsor is the world's best plaintiff. You could not pick a better plaintiff than Edie Windsor. She is adorable. She has a great story. The tale of their courtship, of Thea Spire's demise from multiple sclerosis, it is wrenching. And it's the perfect setup for this case. Dave was right. There are missed opportunities in Windsor, opportunities to elaborate what the tiers of scrutiny might do for individuals who identify as sexual minorities. How do we treat those claims of individual rights? But we don't even get to them in Windsor, in part because Kennedy already sets the stage in Lawrence. In Lawrence, we're not talking about individuals. We are talking about relationships. And that comes into full flower in Windsor. What is protected in Windsor is the relationship that they had here. And it's protected, as Dave says, through the sort of odd melange of due process, equal protection, and federalism, like 3 great tastes that have never tasted great together, all in one opinion. And so it's an odd decision. It's a decision, I think, where Justice Kennedy, in his zeal to stop a train that he got rolling, avoids opportunities to elaborate various strands of constitutional doctrine that really matter to people in the LGBT rights movement. And it also is, I think, an attempt, and maybe conscious or unconscious, to venerate a particular kind of relationship, one that looks just like Thea Spire and Edie Windsor's committed long-term relationship, one that looks like the relationship that Justice Kennedy imagined for John Geddes Lawrence and Tyrone Garner, but maybe not the kind of relationship that all LGBT people are in or aspire to in their lives. So I think this is a decision that does a lot of great work in striking down a law that had very real material effects in the lives of some people. But this isn't a sweeping decision that will affect the lives of every LGBT person in the United States. I think that's something that we should talk about. It's an important decision. It's a path-marking decision. But to say that this changes the game in all respects, that is not the case.
Well, in this case, I want to make it very clear that I am not speaking for the Goldwater Institute. This is an issue in which Goldwater was not involved and in which its staff is passionately in opposition to each other. So I want to tell you where I stand so that my subsequent comments on this will, I hope, potentially have greater weight. I strongly support gay marriage. I agree with the Romer versus Evans and Bowers decisions, one of which Melissa talked about very eloquently. And I may even be persuaded by the fact that bans on gay marriage are unconstitutional. I am a huge supporter of federalism, and in fact, I was very critical of the efforts by social conservatives to go to Washington to regulate marriage, because I do completely agree with Justice Kennedy that this is the quintessential state issue, and the federal government should not interfere with it. Not only that, but Kennedy is the justice with whom I agree the most. He is by far the most libertarian justice on the court, thus I feel a special kinship with him, and I hope he never leaves because I think he plays an important role in the court. And I thought I supported this decision until I actually read the decision. And I promise you that I read the other two decisions before yesterday, but when I read this decision, I thought this was the worst mishmash I had ever seen. And I think David made that same observation. As someone who believes passionately that our freedom depends upon the rule of law, I look at this decision and I have no idea what the rule of law is. If I had litigated this case for the defenders of DOMA, I would have articulated the question as follows. Can a state unilaterally divest the federal government of authority over its benefit allocation? And it seems to be as simple as that. Even though Kennedy goes crazy on the federalism stuff, and we will be citing this stuff in all of our briefs, this case has, in my opinion, nothing to do with federalism, because the federal government has not told the states to do or not do anything. Essentially, what the court is deciding is that the state can tell the federal government how to allocate its benefits. And I think that Alito, who I, by the way, agree with on all four cases, totally nailed it. He said, "We have long made clear that neither the political branches of the federal government nor state governments are required to be neutral between competing visions of the good, provided that the vision of the good that they adopt is not countermanded by the Constitution. Accordingly, both Congress and the states are entitled to enact laws recognizing either of the two understandings of marriage. And given the size of government and the degree to which it now regulates daily life, it seems unlikely that either Congress or the states could maintain complete neutrality, even if they tried assiduously to do so." This is a federal program, and before this decision, every government got to decide for itself what the definition of marriage is. And basically, the court has said the federal government may no longer do this. Also, ironically, this is a federal rule that treats everybody the same. It is a single rule that virtually doesn't trigger equal protection scrutiny at all. It also leads to the anomaly that today, whether you have rights to federal benefits as a gay couple depends on where you live. That actually creates a new discrimination. Having said all of that, I do like that it ratchets up judicial scrutiny under rational basis review, although I wish that Justice Kennedy had actually said this was rational basis review. We are left in the dark on that. One last point, and I think it is very, very important, and I think Alito nails this as well. When we look at this case and the next case on issues of standing, they are irreconcilable. in my opinion. And Alito said this is a congressional advisory group that was allowed to defend a federal law that the executive branch decided not to defend. In the California case, the citizens who put forward the initiative were not allowed to decide it. Alito says either there is standing in both or there is standing in neither. Alito and I believe that there should be standing in both, and we'll get to that later on. But there are a lot of people who, especially on the standing issue, are being very, very inconsistent on both the liberal and the conservative side of the court. And I think, again, for the rule of law, that's very, very troubling.
Well, I'm going to merge some of my comments about Hollingsworth as well. In this collection of opinions, we see two Kennedy opinions, and in my view, we see Justice Kennedy at his best and not at his best. And I'm going to say very little about a gay marriage. We all know that ideas of marriage have been evolving. The old notion of marriage is mainly about protecting children, family wealth, and some degree of financial security for women. And people could end up being very happy or miserable, but that was an add-on. Now, evolving views of marriage are much more concerned with a personal relationship and commitment, where personal happiness is essential, and these cases touch on really the equality and expanding traditional notions of marriage. I'm going to leave that for other comments. I want to talk more about the justiciability issues and the sufficiency or the character of the legal reasoning. Now, I'm going to jump ahead of Professor Marcus, but in the Hollingsworth case, I think we see Justice Kennedy's dissent. We see him at his best. That was the case. I'm sorry I'm ruining your story, where the court held that there was no standing by the proponents of an initiative under state law to defend the initiative in court on appeal when the state officials, who never liked the initiative, colluded with the plaintiffs to accept its defeat. Now, in Arizona, you have standing proponents of initiatives. The court talked about other states where there is standing for that. And Justice Kennedy does a superb job of taking this back to the very theory of initiatives as it exists in a lot of states, especially Western states, that arise out of distrust of politics in the legislature, of vesting lawmaking in some circumstances directly in the people, because we don't trust the government people. What this case says is the government people can, by collusion, defeat that law and by accepting an adverse ruling in a lower federal court and not appealing it. To me, that is maybe it's because I come from living my life in Arizona, practicing law here, and having litigated initiative matters at time to time, not this issue, but I litigated initiative matters. This is just basic to our notion of democracy and how we legislate by ourselves. We do it this way because the people claim this right. And to touch back, I'll come back to this later about possible differences with Windsor. We don't have that in the federal Constitution. The federal Constitution has a separation of powers that is of a somewhat different character. We have the legislative branch, the executive branch, and the judiciary, which is supposed to be a passive institution. And that's where the power lies. The people don't get to deal directly with lawmaking under the federal system. The people do get to deal directly with lawmaking in the states, which is the residuum of our self-government. But it's not a part of our constitutional theory. So I may come back to that if I have time, but there may be principal differences on the standing issues between Windsor and Hollingsworth. There's been a lot of commentary about political motivations about the justices and why they did what they did. It looks like to someone like me who firmly believes in the initiative process and its legitimacy, they gutted the initiative by entrusting the initiative to the people it was meant to control, who were not being trusted. So it is a breathtaking affront to the initiative process and the democracy in a lot of states as we have it. And now, it's also often being talked about as an evasion of a socially and politically explosive issue that the court did not want to deal with. And sometimes that is appropriate in the judicial process. Waiting for the best time to deal with important legal issues is not necessarily in bad faith or inappropriate. I suggest the Supreme Court really doesn't have a claim on our sympathy for dodging this issue, because they just reached out to decide a closely related issue in Windsor. This is, I submit, really a serious affront to democracy as it exists in half the states and as we are used to in Arizona and out west. Now, on the other hand, the Windsor case is pretty startling in its own right, because it was, I suggest, it looks to me like a classic collusive lawsuit. You got two people who agreed, who wanted to have a court bless their position. That is a classic collusive lawsuit. It's not a matter of formality, it's a matter of substance. And this does, and some states allow this, some states provide for advisory opinions from their highest courts. We don't have that in the federal system. Collusive lawsuits are rejected for reasons that are discussed well in Justice Scalia's dissent. But you got parties who didn't disagree, who liked the decision they got, wanted the appellate court to bless it without anybody saying it's wrong. I suggest, and the notion, well, the government didn't pay the tax refund. They didn't pay it. So there's a real dispute. No, there's enough of a dispute. It has just one drop of a dispute, so we'll rely on amici curiae to provide the vigorous advocacy. But that's generally not how we deal. That is generally not at all how we deal with the requirement of genuine cases or controversy. I suggest that what should have happened here is the Court of Appeals should have said, there's no dispute here. This is not a real dispute. This is not a legitimate exercise of the judicial power. And since we know what you're doing, and you're not hiding what you're doing, your appeal is dismissed. And Ms. Windsor has her judgment against the United States government for the tax refund. And she collects her judgment, she gets her money, and the case is over. So how this turns into the appellate courts and the Supreme Court reaching out and deciding a matter of great importance on which there is great social division is quite remarkable if you view it according to standard, cautious, conservative notions about the sparing use of the judicial power, and especially judicial review of federal legislation. That is the most worthy of caution of any of those areas. Now, why did the court do this? Well, Justice Scalia writes his dissent and is more entertaining than he even is usually of his use of language. But he talks about the court hungering to decide this issue. It's hard to quarrel with that. And we can think of times when the court, we have this remarkable, unique institution of our judicial system and judicial review. It is unique. There's no other country who's ever had anything quite like it. And it is, I digress for a moment, I think it is essential for us to have that because for other historical reasons we have a constitution that cannot be amended as a practical matter. It simply can't be amended. So we have to have judicial review to provide some kind of relief in critical situations. But the court has times when it has reached out, and the most famous one, of course, was Dred Scott versus Sanford, where they decided to resolve the burning issue of the day, slavery. So they reached out and decided, well, slaves or Congress cannot regulate slavery in the territories. Oh, by the way, black people aren't even citizens. None of which needed to be decided in that case. Now, I'm not smart enough to know whether that caused a civil war or not. I think it didn't cause it, but certainly accelerated it. A catastrophic usurpation that tainted the court for decades. Some people think the same thing happened in Roe v. Wade with the abortion case. This thing, why did the court do this here? The demographics of the issue of acceptance of homosexuality and gay marriage is obvious. The social acceptance progresses about 1 year per year. It's a generational issue. Approval of this is moving along. In 10 years, we're going to have a 10% higher approval rate. Most states are going to be accepting it. Not all. You'll always have pockets that are different. So of course, it's never an answer to individuals who feel their rights are being denied to say you have to wait till later. Now, last comment on the merits. Everyone here has commented on the loosey-goosiness of this opinion. There's no clear reasoning and no connection to the fabric of constitutional doctrine, which is the test of legitimacy of the judicial function, especially for judicial review of legislation. It just reads like a collection of rhetorical, political, and policy points concluding in a naked choice with indignation. Now, they may well be right as a matter of policy, but it simply doesn't meet the test of legitimacy of judicial or justification for judicial action. It also reminds me of other cases that have received that criticism, like Griswold versus Connecticut, the birth control among married people with umbras and penumbras. Now, umbras and penumbras of substantive due process equal protection and federalism. Now, in Griswold versus Connecticut, the court aggressed. They had a wide public support in that favor. And the state of Connecticut had a century-old statute prohibiting contraception. It could not be appealed because of political influence in the Connecticut legislature from various religious interests, and they were with where our society has gone. Maybe in Roe v. Wade they guessed wrong because the level of public disapproval of abortion of choice is not much different now from what it was 40 years ago. So things had not, they may have gambled and lost on that. And this one, I don't know if they gambled, I don't know if they've lost, because I think that, as I said, within a number of years, public acceptance is going to be predominantly here in any event, which leaves my question of why did the court gamble with its credibility to do this when its social views and the political process was going to get here anyway? Thank you.
I'm just going to, just very quick, we have a couple more minutes. I have a couple of thoughts in reaction to these really wonderful comments. One thing I think that, I don't know if I should call you Melissa or Professor Murray. Melissa. One thing that Melissa said is really worth pointing out or underscoring. Justice Ginsburg has quite famously described Roe versus Wade as perhaps a misstep. This case is really going to pose a challenge to those constitutional theorists who think about individual rights, constitutional lawmaking in terms of backlash. The idea offered by those who argue for judicial restraint in the area of social rights is that the Supreme Court succeeds when it acts to suppress norm outliers. So the state of Texas prohibited same-sex sodomy. It was one of only a handful of states to do so. The rest of the states, something over 40 states had already legalized it. Texas was an outlier that had to be suppressed. The situation is quite the opposite for same-sex marriage. I think at present something like 13 jurisdictions permit it. It is not, the outliers are not the states that prohibit same-sex marriage, but the opposite. And the theory for constitutional theorists of backlash is that a judicial decision that, like Roe versus Wade, that jumps into the fray too soon before there's been sort of a coalescing public opinion on the right direction for social policy, is that the court's decision will just spark, will just inflame those who disagree with it and lead to some massive political response. I don't see any stirrings of that sort of response in this instance. And so I think that to the theorists of constitutional backlash, this case poses some really interesting questions of the dynamics of judicial intervention in social issues. As to the federalism angle that Mr. Bullock Clint mentioned, I think that the First Circuit's decision, this case, the Windsor case came out of the Second Circuit. There was a First Circuit case as well. It was brought by the state of Massachusetts. The state of Massachusetts sued the Department of Health and Human Services because the state of Massachusetts recognized same-sex marriages and risked losing its Medicaid funding, the entirety of its state's Medicaid funding, because DOMA did not allow the state of Massachusetts to recognize same-sex marriages. Medicaid funding in part hinges upon how much spousal income counts for determining thresholds and the like. Massachusetts said, we want to recognize same-sex marriages, but you, the federal government, won't allow us to. This infringes upon our state sovereignty. I think that the First Circuit's case is a far more elegant resolution of this problem, but it's also, it demonstrates, I think, that in many instances, there actually is kind of a problem of the United States government coming in with instead of its scalpel dealing with an immigration problem here or there, as it has done where it defines marriage elsewhere, with this axe that defines marriage for 1,100 federal programs, many of which involve this cooperative federalism angle that puts state policy determinations at risk. And then finally, as to Judge Wake's comment, first of all, note that Judge Wake said that this Kennedy is at his best and not at his best. I would have said Kennedy is at his best and at his worst, but he's a judge and is far better, has more self-restraint than I do.
Except that we're talking about different opinions.
Right. Well, you don't know what I'm going to say about Hollingsworth yet. I think that I'm not totally convinced that the litigation in this case was collusive. That's maybe a strong word. The Obama administration's in a bit of a bind here. If you think about what the administration's obligation is, the Constitution says that the president shall take care that the laws be faithfully executed. Okay, well, there's one supreme law above all other laws, and that's the United States Constitution. So this is an interesting question of the president's obligation when it comes to defending or not defending suits. The president might, take care clause might be thought to oblige the president to defend duly enacted laws that are passed, that go through bicameralism and presentment, perhaps. Or it might oblige the president to refuse to defend when the president, in a good faith, makes the good faith determination that the United States Constitution is simply inconsistent with a statute. So what the Obama administration did here, which is, and this is a possible distinction with Hollingsworth, the Obama administration appealed the decision of the Southern District of New York. It refused to give the money back. In so doing, it enabled those who wanted to defend the law, and that in this instance happened to be this bizarre, poorly named bipartisan legal advisory group, the BLAG. It gave the BLAG a chance to actually defend the merits of the law. In the Hollingsworth cases we'll talk about, the governor, Arnold Schwarzenegger, didn't appeal the judgment. That may be a clearer instance of collusion than in the Windsor case. I don't know what the president was supposed to have done if the president believes his constitutional duty. Let's put it this way. I don't know how if the president believes his constitutional duty obliges him to agree with Edith Windsor. I don't know how the administration could have handled this better than how it did.
How about taking responsibility for their decision, which they have the authority to do as the executive branch, and if they decide we're not going to force, and they don't, and they repay the taxes. So.
My motion has been denied, and at this point, we have to take a break. In our discussion, so our next case is Hollingsworth versus Perry. In our discussion of Windsor, I described the question of whether states can deny same-sex couples the right to marry as the big matzo ball. The federalism angle gave the court an out in Windsor, although it still had to down a pretty hefty pastrami sandwich when it invalidated DOMA. But for another odd procedural wrinkle, Hollingsworth versus Perry would have placed the matzo ball squarely in the Supreme Court's soup bowl. But this procedural wrinkle meant that the court could avoid the deli altogether and choose to dine on much lighter jurisdictional fare. I spent at least 2 hours crafting that kosher deli metaphor, and I'm very happy with it. The story of Hollingsworth versus Perry is far more remarkable than the Supreme Court's technical, dry discussion of standing that ultimately proved dispositive. In the year 2000, California voters approved Proposition 22, which amended the state's family code to deny legal recognition to same-sex marriages. In 2004, Gavin Newsom, then the mayor of San Francisco, and then as now, charming and handsome, declared that he wouldn't be bound by Prop 22 and ordered county officials to start issuing marriage licenses to same-sex couples. When he was ordered to stop, Newsom challenged Prop 22 as unconstitutional under the California state constitution. The California Supreme Court agreed on June 17, 2008. And of course it agreed. Gavin Newsom is charming and handsome. The following 5 months saw the state of California issue 18,000 marriage licenses to same-sex couples. This flurry of wedding activity ended in November 2008, when California voters approved Proposition 8, a proposition that amended the California state constitution to prohibit same-sex marriage. Represented by former Bush v. Gore adversaries, Ted Olson and David Boies, 2 couples sued, challenging Prop 8 as unconstitutional under the United States Constitution. As with Windsor, a funny thing then happened. Just as the Obama administration refused to defend DOMA, no state official in California was willing to defend Prop 8. Even Arnold Schwarzenegger, a model of heterosexual marital bliss, refused to defend the statute, the proposition. So the official proponents of Prop 8, the people who officially put the proposition on the ballot, intervened to take up the defense. In 2010, District Judge Vaughn issued a 136-page decision concluding that no rational, much less compelling interest supports Proposition 8's distinction between opposite sex and same-sex couples. Prop 8's proponents, left to defend the law after the state refused to do so, then appealed. The Ninth Circuit was completely befuddled, as the Ninth Circuit is often completely befuddled, and wondered if the proponents of a proposition had standing to appeal when state officials refused to defend the law. So the Ninth Circuit certified to the California Supreme Court the question of whether, under California law, official proponents of a proposition could stand in for state officials and take up the defense. The California Supreme Court said yes, official proponents do have standing to appeal, not to protect their own interests, but rather to protect the interests of the state. The case went back to the Ninth Circuit, which then affirmed Judge Walker, and the proponents took the case to the Supreme Court. So there's an odd situation before the court. Everyone wanted the court to reach the merits. Now, obviously, the proponents of the ballot initiative had a strong interest in the court finding that they had standing. After all, they wanted to get the decision of the court below reversed. The same-sex couples who filed the lawsuit initially did challenge the proponent's standing in their Supreme Court brief, but not until about 28 pages in, and then only in 2 pages. The rest of the proponents of the couple's brief deals with the merits of the issue. The amici spent very little time on standing. As far as I could tell, only 2 or 3 of the many dozens of briefs actually tackled the standing issue in any serious way. And yet standing, or rather the lack thereof, gave the justices an easy out, an easy way to dodge the big matzo ball, and this is just what happened. Now, the issue before the court was this. If state officials decline to defend a state law enacted through an initiative process, do the proponents of the proposition have standing to defend it? Now, here's why the issue matters beyond its importance for deciding the Hollingsworth case itself. Judge Wake already gestured at some of these reasons, and I'll elaborate. The initiative process is designed precisely to circumvent elected officials. Elected officials refuse to act in a certain way. They refuse to act or enact certain legislation, for example, that the people might demand. The initiative process enables, through an exercise of direct democracy, the people to get the law that they want passed. So an initiative gets passed and state law is now enacted. A suit is then filed to challenge the constitutionality of that new state law. The elected officials, the governor or the state attorney general, are usually tasked with the defense of state laws. But these are the very officials that the initiative process was designed to circumvent in the first place, the officials who are unwilling to enact the law in the first place. These officials have every incentive to refuse to defend the law imposed upon them by the people. If they refuse to defend the law, if the proponents of the initiative cannot take over, and if a court strikes down the undefended law, then the elected officials could undermine the initiative process itself. A version of this argument, at any rate, motivated the California Supreme Court's decision. But a 5-justice majority composed of a somewhat curious coalition, the Chief Justice and Justices Scalia, Ginsburg, Breyer, and Kagan disagreed. To have standing to appeal a district court's decision, Chief Justice Roberts began his majority opinion, a litigant must have an injury that affects him in a, quote, personal and individual way. The litigant cannot have a generalized, undifferentiated grievance that any citizen might have. The official proponents of Proposition 8 had a special distinctive interest in the initiative process up to the moment that it concluded. Had state election officials, for example, interfered with efforts to put arguments for the proposition on state ballot materials, then the official proponents would have had standing to bring a lawsuit. They would have had the particularized injury necessary for standing. But once Proposition 8 passed, Chief Justice Roberts argued, it became a law like any other, and the official proponents resumed their lives as ordinary citizens. They had no personal stake in the law's defense, any more of a stake than any one of us has as just an ordinary citizen within a state. But Proposition 8's proponents did not argue that they had a personal stake in Prop 8's future. Rather, they argued that they asserted this interest of the state of California. After all, when the Attorney General defends a law, it's not the Attorney General's personal interest that the Attorney General is vindicating, but rather the interests of the state. Prop 8's proponents insisted that when state officials would assert the state's interest in a law's, or when state officials would not assert a state interest in a law's preservation, then they should get to do so. And this is what the California Supreme Court held, that California law allows a proposition's official proponents to act on behalf of the state when elected officials refuse to. Chief Justice Roberts, however, disagreed that a proposition's proponents can act as agents of the state. Proponents have no fiduciary obligation to the people, as elected officials do. Proponents are not accountable to the people, as elected officials are. As the Chief concluded his argument, official proponents are free to pursue a purely ideological commitment to the law's constitutionality, without the need to take cognizance of resource constraints, changes in public opinion, or potential ramifications for other state priorities. Interestingly enough, given the legal jujitsu that Kennedy did in his Windsor opinion to avoid the big matzo ball, Justice Kennedy dissented. It's up to California law to define who has standing to defend a proposition, Kennedy insisted. There is no freestanding federal common law doctrine of agency that can displace California's sovereign choice to vest proponents of a ballot initiative with standing to defend it. Kennedy went on to make the policy argument that Judge Wake summarized and that I've summarized a short while ago. To quote his dissent, the purpose of the initiative process is undermined if the very officials the initiative process seeks to circumvent are the only parties who can defend an enacted initiative when it is challenged. So where does this decision leave things? As a matter of same-sex marriage in California, the answer is pretty clear. The issue is whether the proponents had standing to appeal. The Supreme Court's decision nullifies everything that happened after Judge Walker issued his decision enjoining the enforcement of Proposition 8 in the state of California. That decision is now restored and Prop 8 is permanently enjoined. So same-sex couples in California have the right to marry. As a matter of civil rights litigation, my guess is that we'll see this play reenacted in other states, where elected officials may profess a sympathy with same-sex marriage, notwithstanding legislation enacted earlier prohibiting it. Same-sex proponents who pick their battles carefully might be able to go state by state and win some pretty easy victories. I'm thinking of states perhaps like Michigan or Colorado. As a matter of jurisprudence, though, I want to point out an interesting tension, or at least foreshadow one. One can read the Chief Justice's opinion as an exercise in judicial restraint, as an attempt to dodge this big matzo ball. I'm not going to talk about kosher food anymore, that's the last reference. One can also read it as an act of judicial aggression. After all, the decision amounts to a denial that states can define for themselves who can defend their laws. This is inconsistent with a commitment to federalism. The Chief's willingness to turn his back on state sovereignty in the Hollingsworth case stands in somewhat stark contrast with his aggressive embrace of state sovereignty in the Shelby County opinion, but more on that in a short while.
Well, while all of this talk about food was going on, I think I figured out Just Kennedy. Every year, Justice Kennedy hires 2 law clerks. One of them is a JD from a distinguished law school like Yale or Harvard or my alma mater, UC Davis. And the other is a PhD candidate in romantic literature. It was the latter who wrote the decision in the other case, and the former that wrote the decision in this one, because this is a model of cogency and legal reasoning. This is really a disastrous decision. It's a disastrous decision for anyone who believes in popular democracy, and as Judge Wake said, in the initiative process, because in many instances, unless the ballot measures confer rights directly upon a class of individuals, there will be no way to defend them. When a referendum or an initiative is passed, the people are acting as the sovereign. More than that, they are acting both as the legislature and as the executive branch. And it's supposedly the executive branch that has standing in these instances. They're not enforcing the law, but they are essentially signing the law into law, because a referendum or initiative needs no executive signature. The whole point of an initiative is that either your legislators or your executive disagrees with you. In this particular instance, even as David pointed out, the California Supreme Court unanimously held that groups defending a defensive marriage initiative had standing to do this on behalf of the state of California. I think that the standing decision in the other case was correct and is wrong in the California case, because in both instances, the people defending the law were really the real party in interest. In the first case, it was Congress. In this case, it was the people who put the referendum forward. I agree with Judge Wake that in particular, this was a collusive lawsuit. And the court gets into this agency rationale where the state has not given the people an agency relationship to defend the state, and they have to follow the restatement of agency in order to have standing to represent the state. And if you go back to the founders of our Constitution, that has it exactly backwards. The people are not the agents of the state are the agents of the people. And so when the executive is defending someone, a law, he or she is acting on behalf of the people. Why then should the people not be able to act for themselves? So I think this is a really, really disturbing decision. I cannot believe that Scalia would sign on to a decision like this. Just a few years ago, the U.S. Supreme Court decided a case called Wynn, in which taxpayers standing to eliminate or to challenge funding that might represent a religious establishment was considerably narrowed. And Ginsburg, Breyer, and Kagan dissented from that, saying that there should be standing, but here they are supporting the majority decision in this case. The one liberal justice who got it right, not surprisingly, is Melissa's former boss, Justice Sotomayor. This case was trumpeted as a victory for gay marriage, but I think that David got it exactly right. Although it was a victory for gay marriage in California, the result of finding no standing was that the U.S. Supreme Court did not decide the big matzah, so to speak. And I think that one of the reasons that Kennedy was so exercised is that he wanted to decide the case. So perhaps the 5 justices, Roberts, Scalia, Ginsburg, Breyer, and Kagan, who ruled that there was no standing, none of them were absolutely certain that they had 5 votes on the really big issue. And frankly, reading Kennedy's decision, steeped as it is in federalism, on the one hand, and individual rights on the other, it's not totally certain how he would come out on that central issue. I think ultimately he would find that marriage is a fundamental right, and would strike down laws forbidding gay marriages. But that's just a guess. and it's a big gamble for justices to take. But by avoiding that gamble, 5 justices eviscerated the referendum process, and to me that is too high a price to pay for whatever goal that they may have had in mind. I do want to say that the Goldwater Institute, and I'm hoping my friend Paul Avalar at the Institute for Justice will join us to put our heads together to figure out how in Arizona, where the initiative process is so central to our form of governance, for better or worse, how we might in fact be able to establish after this Supreme Court decision that people do have the power to defend the constitutionality of measures approved through the ballot. And if we do, perhaps we'll be able to make this decision a little less dreadful than it actually is.
This decision has all the look of an evasion, but we're stuck with it now. But there might be opportunities where small distinctions are given weight. So there hopefully there will be room for hope. I also wondered whether this might be kind of an East-West thing, because all the justices who voted against, they're all Easterners. They don't get it how we do it out here. But then all of the other justices were Easterners too, except for Justice Kennedy. So I miss the days when we had 2 justices from Arizona. So, but, I already said my thoughts on this. So I will take just a moment to go back and make a brief comment on the other one, since I didn't want to use up too much of my time or go too far over time. And that's going back to Windsor. The other thought that I thought worth comment is that there are arguments to be made for and against the Defense of Marriage Act, at least or especially in the context of this case of estate taxes. It's, well, actually Clint touched on it. That is, the federal decision as to how to treat marriage and estate taxes is really, it's a form of economic subsidy. There is a lot of subsidies or disadvantages in the tax laws pervasively, but in all laws. And there was a decision here that we don't want to subsidize this classification of marriage. I'm not saying that carries the day, but it deserved being mentioned. It should have been said, and said why it was wrong. Instead of the real reasons were essentially ignored, and Justice Kennedy said, well, this is really born out of animus, or as Justice Scalia said in his disparaging characterization, that they declared the overwhelming majority of Congress and the President who signed it, hostes humanis generis, Latin for enemies of the human people. So, well, it deserves some discussion as to why that and other reasons should be rejected as a matter of constitutional law. So I think I went too long last time, so I'll wrap that up for this time.
So I think my role on the panel is to reach back and identify old chestnut Supreme Court cases that remind me of the case at issue, and I have one for this case. I think Clint's exactly right in trying to sort of figure out the strange bedfellows that have coalesced around both the majority and the dissent here. And I think you're right. I think there is a group who doesn't want this decided at all, and they come together to form this majority, and I think the dissent is a group that would happily decide it for different reasons. Mm-hmm. And I think that's the dynamic that you're seeing here. And that sort of relates to my point about this old Supreme Court chestnut. As many of you know, in 1954, the Supreme Court unanimously decided Brown versus Board of Education, which overruled Plessy versus Ferguson and eliminated segregation in the South. Brown was a phenomenally controversial decision. Today we talk about it in these vaunted tones, like it's sort of the axiomatic decision of rightness, of the Supreme Court getting it right, but that wasn't clear in 1954. And in fact, one of the issues that was very live in Brown was not just about the desegregation of public schools, but the possibility that the desegregation of public schools would lead to the integration of private bedrooms. Right? So this is a live issue in 1954. The idea that desegregation would lead inexorably to interracial marriage. And lo and behold, in 1955, the year after Brown is decided, the court gets a certiorari petition on a case called Name versus Name, which is challenging a Virginia statute, the Racial Integrity Act of 1927, that prohibited interracial marriages between persons of the white race and all other races. It's the same statute that, interestingly, is struck down in 1967 in Loving versus Virginia. So the court in 1955 has the opportunity to make a statement, to expand the logic of Brown to also include the question of interracial marriages, and it doesn't. It doesn't take the bait. It denies certiorari. It refuses to hear the case. And it does so through a series of judicial gymnastics that some find incredibly unprincipled. Michael Klarman has written quite eloquently about this. Doesn't take the case. 13 years later, it takes cert on Loving versus Virginia. Maybe it's because the name is better. Loving versus Virginia works better. But I actually think what's going on is something that Dave alluded to in his remarks, the same thing about Lawrence. 13 years pass between 1954, when Brown is decided, and 1967, when Loving is decided. And in that intervening time, a number of states, many of whom have laws prohibiting interracial sex and interracial marriage, repeal their laws or judicially invalidate them on their own. So there's progress. By the time the court comes back to the issue in 1967, there are 16 outlier states, all in the South, but there's a national consensus that has emerged, and the court's job is a consensus-making court. It's a cleanup court, herding recalcitrant jurisdictions into line, into what has become a national consensus. I think when we think about what is going on in Hollingsworth versus Perry, we can't forget versus Name, because that's exactly what's going on here. Why do you have this strange coalition of odd bedfellows? Because there is a group, Justice Ginsburg, Justice Kagan, Justice Breyer, who don't want to see this case heard yet because they want the political process to play out throughout the states, because they're worried perhaps about backlash, because they're worried about other things, because they recognize that there's stuff going on at the state level that perhaps should be offered the opportunity to play itself out. And so they punt on this. I think the standing issue, I think the reason why you have two completely similar standing issues in these two cases decided completely differently is because this is a punt. They are punting here so they don't have to reach the merits of this case, because there's going to be another case where the same facts are going to be presented. Maybe you don't have the same issue with the state executives refusing to endorse the law, but you still have the same issues, but there's some kind of work that has been done at the state level, and there's more evidence of a national consensus. I think that's cold comfort for those LGBT couples who believe that justice delayed is justice denied, but that's what I think is going on here. This is a punt to divert this issue until another day when the court can actually bring the recalcitrant jurisdictions into line and make a decision that is in keeping with what has emerged as a national consensus. So I think Name is something that we ought to think about here. I also want to sort of note, we ought to think about the role of the executive branch in the LGBT rights struggle and the struggle for marriage equality in particular. It is interesting to me that some of the actors, the most influential, important actors on this issue have been municipal level mayors. Gavin Newsom, the mayor of New Paltz, New York. Governors like Jerry Brown and Arnold Schwarzenegger, who did not come back, but he's still nonetheless a big part of this litigation. And then the president and the attorney general. We normally think in the course of constitutional law as the court itself, and federal courts in particular, as agents of change and transformation. But here, we have executive actors who are the engines of change, who prompt this whole process and set it forward. We would not have Hollingsworth versus Perry if Gavin Newsom had not taken that unprecedented step of allowing those same-sex marriages to occur in defiance of Proposition 22. We wouldn't have had Gavin Newsom doing that if Gavin Newsom hadn't gone to the State of the Union address in 2005 and heard then-President George W. Bush talk about support for a broad federal amendment defending marriage that would outlaw same-sex marriage as a matter of constitutional law. We wouldn't have had Gavin Newsom do that if he hadn't been there at the State of the Union to hear that, become incensed, gone back to California, talk to his legal team about what the scope of the California constitutional law meant in terms of this issue. So this is an interesting moment just to think about who the actors are on Constitution Day. It's not just courts, it's not just legislators. There are lots of different people, executive actors of all stripes and at all levels who are transforming the system and playing a role in making all of these things happen. And then finally, I wanted to say something about the initiative process, and I hope this will not anger the Arizonans because I really want to go to dinner tonight. So don't get mad. I live in California where all of this played out, which has a very strong tradition of the initiative process. I totally understand the role that the initiative process has played in Western political life, in the culture of the Western legal systems. But there is something deeply problematic, at least to me as an outsider, about a system where a majority can take away a conferred right that a minority enjoys. I mean, that's what happened in Proposition 8. The California Supreme Court said that same-sex couples could marry, and then a majority, a bare majority, of Californians through the popular process took it back. Like, what would we say if the California Supreme Court affirmed a right for African Americans in California to vote, and then we had a majority of Californians saying that, no, we weren't going to do that? We would be appalled. So the initiative system is something that I think ought to be cherished. It is a peculiar and distinctive marker of the legal culture of the Western states. But it isn't infallible, and perhaps it needs some limits, and maybe this is one opportunity where there's a limit that has been imposed, and maybe it's the wrong limit, but perhaps it's something we ought to think about.
Could I make a brief comment, or two brief comments? First, I totally agree with what you just said, and I have no trouble with a court overturning an initiative that is unconstitutional. This, of course, is the different question of whether someone will be allowed to defend that initiative, and ironically, the result of not allowing them to do so is that they never got to that very issue that you were saying. The other, I loved your history and your analogy on this very issue, and I think that your diagnosis of what the court did here is absolutely right, but it seems to me the height of judicial irresponsibility to grant cert in a case that it's, and then decide that it's scared.
Is that a cert case or an appeal case? I don't remember.
It's a cert case.
Okay.
If they were going to do such damage to the doctrine of standing, then dismiss the case as cert having been improvidently granted. So I think they had options.
Well, they couldn't do that because you only need 4 votes to grant cert.
Right.
They could have done a dig and just said
Yes.
cert was
But they
improper.
wouldn't need, well, yeah, they could have. Yeah.
And I think there were 5 votes to do that. So I just don't understand it. It's such a tragedy that was totally unnecessary.
I think that Justice Kennedy suggested that at oral argument, I don't know if it was in Windsor or Hollingsworth, but Hollingsworth suggested that the case be dismissed as improvidently granted. And I wasn't, I wish I had, but I wasn't in the courtroom. But people who were in the courtroom told me that the Chief Justice's head turned around at 360 degrees when Kennedy suggested this, because it would be an affront to his stewardship of the court to think that they would make a mistake along those lines. I agree. There would have been the option of dismissing as improvidently granted. I have a question for the panelists. This goes to Melissa's point about who the actors are that prompt constitutional change. One of the a very central figure in this whole drama was, of course, Judge Walker in the Northern District of California. I found the role of the trial in this incredibly complex and challenging issue of social policy, the role of the trial itself, really interesting. And I wondered what my panelists thought. On one hand, you have a bizarre situation, as Justice Alito pointed out in his in Windsor dissent in a footnote, you have this bizarre situation where a district judge is making findings of fact as to what marriage is. On the other hand, a civil trial, or a trial imposes a certain discipline on political discourse that's lacking in any other forum. People have to swear as to what they're saying is being true. And they are subject to cross-examination. And I feel as if some of the discourse about gay marriage really benefited for the fact that it was filtered through the mechanism of trial. But I'm interested in the panelists' thoughts on this issue.
Well, I'm looking for that footnote. He has a comment about how, what was the word he used again? Kind of, it wasn't silly or ridiculous, but meant something like that. Of the trial judge making findings of fact on these questions of sweeping social reality or debate, and suggesting that that's not at all what findings of fact are about under Rule 52. And I remember Vaughn Walker is a great judge, a fine guy. But when that trial was going on, I wondered about that, and so this footnote hit it for me, which is, it reminded me of the distinction in administrative law that I think was coined by Kenneth Culp Davis back in 1940, which is now common in administrative and other areas of law, of the distinction between legislative facts and adjudicatory facts. That facts of the specific case that decide who wins a particular case, was the light red or green when your car entered the intersection, that's an adjudicated fact. Legislative facts are facts about the world that are of a broader nature that legislators think about and have their notions about when they decide to adopt or not adopt a general rule. I thought Judge Walker was just having a trial on legislative facts and making findings about legislative facts, which had no legitimacy at all. And obviously Justice Alito was contemptuous of that.
Leaving aside the difference between legislative and adjudicative facts, this was just political theater. I mean, this was a case that could have been decided on summary judgment very easily, done on the papers. But there was a conscious decision made to have the political spectacle of a trial. And I was fortunate enough to be in San Francisco. I went to the trial, sat in one of the overflow rooms, and there needed to be multiple overflow rooms. But there was something incredibly searing and visceral about watching Chris Perry and Sandra Steyer get up on the stage and talk about their relationship, about what this meant to them. And it was even more important, I think, to have the experts on the other side talk about all of the rationales for disfavoring same-sex marriage. And I think it became clear that a lot of the rationales, by the time they were sort of made public and ventilated, didn't hold water in the way that many expected them to. Like you could poke holes in them. And I have to say, Ted Olson and David Boies were masterful, especially David Boies, who did most of the cross-examination here. I mean, he eviscerated David Blankenhorn. I mean, David Blankenhorn later recanted on himself publicly after the trial. I mean, completely turned and did an about-face. That was what the trial was about. Like, the findings of fact, the opinion, which is lengthy, that Judge Walker wrote, which is essentially a love letter to Justice Kennedy. But that was not the point of the trial. The trial was about changing hearts and minds in California and elsewhere, people reading about this, and there was that huge decision about whether or not the trial ought to be televised, if it should be televised, and it wasn't, ultimately. But that didn't stop people from recreating from the trial transcripts every day what had happened the previous day. So it was this amazing moment of political and legal culture just being played out, and the trial as sort of the centerpiece of all of it.
Ted Olson and Vaughn Walker are both good friends of mine, and I was enormously proud of their role in this. In particular, Ted has been absolutely vilified in some conservative circles for the role he played, and I just really admire someone who will stand up for his beliefs, even if they are unpopular among some of his very, very closest friends. So that really is a test of someone's fidelity to his or her principles. The 2 points that I would make, one of the things I love about being a public interest litigator is that cases can be incredibly powerful teaching moments. And I totally agree with Melissa that this really, really was. And different people would take different lessons from it. But we are now in an era, of course, when trials are brought into our houses for better or worse, in most instances worse. But I think on this one, you had absolutely the best, not only the best advocates that you could possibly ask for, but the individuals whose rights were directly affected, telling their stories not through briefs, but with their own voices. And I think that's absolutely phenomenal. The other point is totally constitutional law nerdy, and that is, once again, the rational basis test, which at least at the moment continues to appear to apply to sexual classifications by government. And basically this is an area of the law that applies to many classifications that government imposes upon people. And the fact that there was fact-finding in this case is highly unusual in a rational basis case. And I hope that that precedent takes hold for liberties such as the right to earn an honest living that I am deeply engaged in.
Any more thoughts? Okay, well, we'll move on to our last case then. Yes, I think we might have plenty to say about this one. Our last case is Shelby County versus Holder. I don't really have anything lighthearted or amusing to say about this one. Shelby County versus Holder demolished perhaps the most successful piece of civil rights legislation in American history. The legal obfuscation that besmirches the demise of the Voting Rights Act could not contrast more sharply with the moral clarity of the act itself. On February 26, 1965, in Selma, Alabama, the great civil rights leader James Bevel visited the family of a man named Jimmie Lee Jackson, who had died earlier that day. Jimmie Lee Jackson was killed by Alabama state troopers when he tried to protect his mother after the police attacked a peaceful voting rights march through a neighboring town. Jackson's family asked Bevel to make sure that the marches continue in his name. After all, Jimmie Lee Jackson, a U.S. Army veteran, had tried and failed to register to vote 5 times. That night, Bevel told the story of Mordecai and Esther to an audience at a chapel in Selma. Just as Mordecai had told Esther to go and see the king on behalf of her people, Bevel preached, black Alabamans should go and see their king, Governor George Wallace, on behalf of their people. On March 7, 1965, the first of 3 marches from Selma to Montgomery began. That night, 48 million Americans watching Judgment at Nuremberg on television witnessed 15 minutes that the movie was cut into, it was interrupted, and these 48 million Americans watched 15 minutes of footage of the Alabama state troopers stopping the march with extraordinary violence. On March 15, 1965, Lyndon Johnson, a son of the South, ended his call for voting rights quite famously with the phrase, "We shall overcome." On March 21, 1965, as the marchers finally reached Montgomery, LBJ sent his voting rights legislation to Congress. On August 6, 1965, Lyndon Johnson signed the Voting Rights Act into law. And on August 20th, 1965, Jimmie Lee Jackson's grandfather, a son of a slave, registered to vote. The Voting Rights Act of 1965 is often referred to as the most successful piece of civil rights legislation in American history, as I just suggested. Here's how it worked. The statute enforces the 15th Amendment, which guarantees that no one be denied the right to vote on account of his or her race. The statute grants a right of action that either private persons or governments can avail themselves of to enable suits to challenge racially discriminatory voting measures. But the heart of the statute lies with an administrative provision, or at least it did. Section 5 of the statute requires that certain jurisdictions get preclearance, or basically permission, from the Department of Justice or a 3-judge court in Washington, D.C., before these jurisdictions change their voting laws. Preclearance of changes to voting laws requires that the change have neither the purpose nor the effect of denying or abridging the right to vote on account of race or color. Section 4 of the Voting Rights Act contains a formula that determines which jurisdictions are covered and thus which jurisdictions must get preclearance. Under the original legislation, A jurisdiction was covered if it used a test or device, like a literacy test, as a prerequisite to voting, and if it had less than a 50% registration or turnout rate in the 1964 presidential election. In 1965, this formula meant that jurisdictions in the Deep South and one county in Arizona were covered, had to seek preclearance before they could change their voting laws. The 1965 Act contained a sunset clause. The statute would expire in 5 years. So in 1970, Congress reenacted the statute, basing the Section 4 preclearance formula on voting statistics from the 1968 presidential election. In 1975, Congress reenacted the statute again, basing its formula on the 1972 election, and extended the law for 7 years. Importantly, the 1975 Act also included as a determinant of coverage whether a state provided materials in languages other than English about voting in jurisdictions where there was a substantial non-English speaking population. This meant that Arizona was now covered by the Voting Rights Act. In 1982, Congress yet again reenacted the statute, this time for 25 years. The 1982 statute curiously left the coverage formula unchanged. That is, whether a jurisdiction had to seek preclearance would depend upon statistics from the 1964, 1968, and 1972 elections. But in 1982, Congress expanded the ability of jurisdictions to, quote, bail out of this preclearance coverage by showing, jurisdictions could do so basically by showing 10 years of compliance with the statute's substantive provisions. For the last time, Congress reenacted the Voting Rights Act in 2006. After compiling about 12,000 pages of a legislative record showing race-related problems both nationwide and in covered jurisdictions, Congress extended the Voting Rights Act for 25 years. As it had in 1982, Congress did not update the coverage formula, relying on voting statistics for coverage from the 1970s to determine which jurisdictions had to seek preclearance. Each version of the Voting Rights Act weathered a legal challenge. When the Supreme Court affirmed the 1965 version in South Carolina versus Katzenbach, its approval of the statute was unequivocal. As against the reserved powers of the states, the court wrote, Congress may use any rational means to effectuate the constitutional prohibition of racial discrimination in voting. Challenges to subsequent versions of the Voting Rights Act met with the same fate in 1973, 1980, and 1999. In 2009, however, the Supreme Court changed its course in a case called, well, it's called something, but the abbreviation is NAMUDNO, a name every bit as ugly as the opinion itself. A utility district in Austin, Texas, challenged the Section 4 preclearance formula as unconstitutional. The court ultimately dodged the issue by interpreting the Voting Rights Act in a very contorted way, but not before the court expressed serious doubts as to the constitutionality of the preclearance provisions. A curious principle appeared in American constitutional law, the principle of equal sovereignty. A departure from the fundamental principle of equal sovereignty, Chief Justice Roberts wrote in his NAMUDNO decision, requires a showing that a statute's disparate geographic coverage is sufficiently related to the problem that it targets. The Chief wielded this strange, and to my mind, entirely novel formula, or principle rather, to demolish the coverage formula of the Voting Rights Act in the Shelby County case. Shelby County, by the way, is about 70 miles from Selma. Congress did not make adequate findings to show that the jurisdictions singled out by the coverage formula, a formula based on election data from the 1960s and 70s, are uniquely prone to discriminatory voting practices. The Chief marshaled some data to suggest that voting patterns are no more problematic in covered states than they are in states that do not have to seek preclearance. As Roberts insisted, Congress, if it is to divide the states, must identify those jurisdictions to be singled out on a basis that makes sense in light of current conditions. It cannot simply rely simply on the past. Hence, Section 4 of the Voting Rights Act, the formula for determining who has to seek preclearance, is unconstitutional. If Congress wants to continue to subject some states to the preclearance requirement and not others, it must devise a new coverage formula. Now, this is basically a summary of the majority decision. Justice Ginsburg penned an impassioned dissent, which the other 3 liberal justices joined. So why do I say that the Chief Justice's decision is a model of legal obfuscation? Let me provide 3 reasons. First, where does the principle of equal sovereignty come from? The Chief cites to a 1911 case that is completely inapposite if you actually read the opinion. What he really did was to launder a line from South Carolina versus Katzenbach, the 1966 decision upholding the 65 version of the Act, to launder a line from this decision through his Namudno opinion. Here's the Katzenbach line. In acceptable legislative fashion, Congress chose to limit its attention to the geographic areas where immediate action seemed necessary. The doctrine of the equality of the states invoked by South Carolina does not bar this approach, for that doctrine applies only to the terms upon which states are admitted to the Union, and not to the remedies for local evils which have subsequently appeared. Now here's how Chief Justice Roberts quotes this line in his Namudno opinion. The doctrine of the equality of the states, ... does not bar ... remedies for local evils which have subsequently appeared. In other words, Roberts, in his Namudno decision, removed the line from Katzenbach that limits the equal sovereignty doctrine, whatever it is, to police the conditions upon which states are admitted to the Union. A limitation that would preclude the equal sovereignty doctrine from doing any work whatsoever in Shelby County. Presto changeo, Roberts wrote his Namudno decision in 2009, has his equal sovereignty doctrine, and then can set off this time bomb, as Richard Hazen, the scholar of election law, quite rightly described it in his 2013 Shelby County opinion. Second reason why I think this is a case about legal obfuscation. What possible relevance to voting rights does the equal sovereignty doctrine have? Chief Justice Roberts begins his analysis with the 10th Amendment, suggesting somehow that this principle emanates from its text. The 10th Amendment states, quote, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people." The Chief, when he begins his analysis, doesn't quote the 10th Amendment, but rather paraphrases it. The 10th Amendment's not strong enough for him. This is the Chief Justice's paraphrase, to quote the opinion. The Constitution provides that all powers not specifically granted to the federal government are reserved to the states or the citizens. This amplifying language, specifically granted, is not enough for the Chief, though. What's worse, the 10th Amendment strikes me as entirely irrelevant to this case. The 15th Amendment explicitly grants Congress the power to enforce its prohibition on discriminatory voting laws, and to do so in a way that doesn't treat all states equally. This is a post-Civil War amendment. To paraphrase Justice White, one would think that the Civil War never happened upon reading this decision. The question in Shelby County is not whether the 10th Amendment somehow limits Congress's power, but whether Congress validly exercised power under the 15th Amendment when it enacted the Voting Rights Act in 2006. The 15th Amendment doesn't appear in the Chief's opinion until about 20 pages in, and then just in passing. And then third, was Congress's record of current need for the coverage formula so sparse as Roberts suggests? Of course not. John Bates, the district judge who upheld the statute in his decision, wrote about 15 pages summarizing the extensive evidence, both of need for preclearance generally and more specifically why the jurisdiction singled out by the Section 4 formula particularly needed federal government supervision. The Chief does little more than include a chart showing that black and white voter registration numbers in covered jurisdictions are about the same. But what he doesn't mention is that the statistics he cites includes Hispanic voters with white voters. If you compare the rates of voter registration and turnout for African Americans and non-Hispanic whites, then the picture is far more bleak than the court's opinion would suggest. I will admit that Congress left the preclearance formula in place in 2006 primarily for political reasons, that Congress simply did not have the political will to adopt a more updated coverage formula. But Congress does a lot of things primarily for political reasons, and most of the time the court is supposed to defer. This is particularly so when Congress is trying to protect a fundamental right like the right to vote, or when Congress is trying to protect against race discrimination. And as Justice Ginsburg says, at these moments, Congress's power is at its maximum. The Voting Rights Act did not deserve to die, but it certainly deserved a more dignified death than the one that the Chief visited upon it. If you will now excuse me, I'm going to go slam my head in the door.
So, the Voting Rights Act case, Shelby County, has been talked about often in conjunction with Hollingsworth versus Perry and United States versus Windsor. And the reason why people talk about them together is it seems like all of these cases are cases that involve questions of civil rights, individual rights, but yet two very different views of how the court should move to protect rights in those particular cases. In Hollingsworth versus Perry, United States versus Windsor, primarily in Windsor, the court seems to take a more protective stance, striking down the Defense of Marriage Act, punting on Hollingsworth versus Perry, whereas in Shelby County, the court basically eviscerates the Voting Rights Act. But a death by 1,000 cuts, because as Section 4 falls, Section 5 is immobilized, and it seems that other parts of the act are also jeopardized as well. So why is this? Why, on the one hand, do you have this apparent attentiveness to the rights of LGBT citizens and perhaps a lack of attentiveness to questions about voting rights and voter irregularities and representation in the political process on the other hand? And I think you can actually boil it down to the phenomenon of first and second generation discrimination. So first generation discrimination, I would posit, is sort of the clear, obvious, bald forms of discrimination, right? Police hosing down individuals on a bridge in Selma, lynching voting rights workers in Philadelphia, Mississippi, leafletting a Colorado town just in support of Amendment 2 and calling LGBT persons vampires who prey on the blood of individuals. This is what was at stake in Romer versus Evans. One of the tactics that was used to promote Amendment 2 was leafletting and saying that LGBT persons drank blood and were vampires and all sorts of things. That all established clear animus in Romer versus Evans. The first generation discrimination are situations where you can clearly see the discriminatory animus that underlies the policy or the actions. Second generation discrimination, I would posit, happens like 10, 15, 20 years after those initial discriminatory acts. And it's harder, I think, to discern them as discriminatory. They're more subtle, they're more nuanced. It's not a coincidence here in Shelby County that a lot of the various pre-clearance issues that the Department of Justice undertakes to look into are about redistricting, not necessarily about literacy tests or poll taxes or things that were first-generation examples of voting discrimination that occurred and prompted the Voting Rights Act. Redistricting in order to dilute the votes of minority voters. Redistricting to create supermajorities by putting together different districts that might vote in a particular way. It's not obvious on the face of it that those are animated by racial discrimination, and it takes a lot to sort of unearth what might be there. And I think that's the point that Justice Ginsburg is making in her dissent. There's a lot going on beyond the surface that isn't necessarily apparent on the face of things. And I think that's why you have two different outcomes in these two sets of cases, both of which are united by an interest in individual rights. On the one hand, in Windsor and in Hollingsworth, the discrimination is obvious. You have a record in DOMA with congressmen going on record talking about gay people and saying really derogatory things. On the other hand, you have in Shelby County questions about redistricting, massing together different municipalities to create new towns and new voting blocks. That doesn't quite sound like rank discrimination in the way that it might, the way a literacy test might or a poll tax might look like. So I think that explains the difference in these two sets of decisions, both of which are united by their interest in individual rights. I also want to make a point, Dave, I think you'll love this because I'm going to bring it back to American Express. Section 2 of the voting, wait for it.
This is true, this is masterful.
This is going to be masterful. Section 2 of the Voting Rights Act, as Dave said, is sort of the heart of it, right? That's what authorizes individual lawsuits or allows the Department of Justice to prosecute lawsuits of voting rights irregularities and violations. But again, those lawsuits are so hard to bring. For individuals to launch a lawsuit challenging some municipalities' record on voting rights requires resources to get the experts to sit there and amass evidence. It would take years for this to happen, and indeed, it would likely take an election cycle or two in order to get what you needed to launch a viable lawsuit. What Section 4 and Section 5 in authorizing preclearance and providing a formula for determining who is subject to preclearance does is kind of provide a sort of alternative dispute resolution forum for processing those things in a quick manner. You see something going on, you bring it to the Department of Justice, you're in one of these covered jurisdictions, and they go ahead, they investigate it, and they decide whether or not, whether they're going to preclear it. So it requires the individual municipality or state actor to put forth all of their changes to the DOJ, and the DOJ has to look at it and decide whether or not it's going to comport with the Voting Rights Act. That's what preclearance does. It takes the onus off the individual from prosecuting those voting rights irregularities by themselves, because doing so would be remarkably onerous for individuals and even for individual municipalities. A huge source of resources would be consumed. It would just be incredibly burdensome, I think, for individuals and municipalities to do that. So it's a problem, I think, that Section 5 is immobilized by the evisceration of Section 4, which provides the formula. And I think we can place the blame for all of this, I think, squarely on the shoulders of Congress. Congress was given an opportunity after Namudno to change the formula. I mean, that's essentially what Chief Justice Roberts was doing in Namudno. Hey, guys, this doesn't make sense. This is not what's going on in the country right now. We can talk about whether or not that's correct. And you need to do something that models and reflects what's actually going on on the ground in these jurisdictions. And Congress, because I think of the poisonous environment in Washington, it's not a bipartisan atmosphere. It would be hard to craft something that would appeal to both sides of the aisle. They punted, and they just simply re-upped with what they had before. And that's a failing. I think that's what leaves Shelby County open and vulnerable, and leaves the Voting Rights Act open and vulnerable in this case. And then finally, I just want to direct your attention, if you haven't looked at it, to Justice Ginsburg's account of what's going on the ground. Chief Justice Roberts paints a vision of legal progress that I think is right in part. Lots of things have changed, and to say it's not progressive is to miss the point. Something has happened, it's incredibly progressive, and it's because of the Voting Rights Act. But that doesn't mean that there isn't work left to do. And Justice Ginsburg's account of what is going on the ground is sobering and heart-wrenching and appalling if you read it. Like, we have made lots of progress, and the Chief is exactly right on that. But as Justice Ginsburg points out, we have a while to go. And eviscerating the Voting Rights Act, I think, does us a disservice, puts us back, and puts the whole question of racial progress on the issue of voting behind.
I have a slightly different view.
I thought you would.
David's summary of this opinion began and ended with the assertion that we have the demise of the Voting Rights Act. That is pure hyperbole, and it is utterly and totally untrue, although some people reading the news accounts from this decision would think it so. This should have been a 9-0 opinion. The way it came out, I was actually surprised that it was 5-4, and frankly, it shows how liberal the four justices are, that this was not a 9-0 decision. I'd like to start with an analogy. Think of someone who's committed a serious crime and is sentenced to jail for 5 years. At the end of the 5 years, after the person has served all of those years, the court says, you know what, let's keep him in there for a little while longer. And then keeps doing that, and keeps doing that, and keeps doing that. And then 41 years later, the court says, you know what, while this guy has been in jail, he has not committed a single crime. This is really working. So let's sentence him to an additional 25 years. That is exactly what has happened here, except that the person who committed the crime is not an individual, but the state. And states, like individuals, have a very significant role in our constitutional system. It is not something, a curious principle that just emerged out of whole cloth. It came out of the 10th Amendment and the 11th Amendment. And so what we're doing here is balancing constitutional amendments, which often occurs. And in the Katzenbach opinion, which upheld the original Voting Rights Act, the court recognized that this was an extraordinary imposition on states but it was limited to 5 years, and it was limited to the wrongdoers. And I think that was an absolutely correct decision. It's very important to understand how the Voting Rights Act works and how Section 5 works. Section 2, I agree, is the heart and soul of the Voting Rights Act. It is what forbids the kinds of things that we think of as discrimination in voting, preventing people from going to the polls, intimidation, and all of that sort of thing. Section 5 is an extraordinary imposition. I always like to use sports analogies. It is like a penalty box in hockey, except far more burdensome and of far greater duration. It is not, as David describes it, requiring preclearance, which is permission from Washington, D.C. to change voting laws. It is permission to change laws that affect voting, so that if the DMV wants to close one of its locations, it has to ask Washington for permission to do that because DMV registers voters, and this might be a discriminatory action. Not only every state and every municipality, but every little district, a fire district, if it changes its boundaries, has to go to the Justice Department and request permission. These are core state functions. This is an expensive process, and David mentioned the bailout process. Each individual entity has to go and seek permission to get out from under the Justice Department's thumb. In Arizona alone, this would be thousands of petitions, incredibly costly, and so very, very few entities actually do it, and they continue to bear the enormous expense of having to seek preclearance. Arizona in particular is a victim of this, because even though Arizona was never in the category of states that in terms of the types of actions it took, in 1975 when the definition of the coverage was expanded, Arizona was swept in to protect language minorities. And that was because even though states didn't realize that they had to do it, Congress retroactively said that if a few years ago you didn't have dual language ballots in districts that had more than 5% of foreign language speakers, you're swept into the coverage of the Voting Rights Act. So Arizona should never have been there. Arizona had a Latino governor when this was imposed upon Arizona. Arizona should never have been in the penalty box. It should not be today. What offended the majority of the court was not the Section 5 process, which was not struck down, certainly not Section 2, which was not struck down, but the fact that current penalties were imposed upon states based on data that is 40 years old. A completely black jurisdiction would still today have to seek preclearance from the Justice Department or a bailout based on what existed 40 years ago. And it doesn't seem at all to me to be, it seems to me to be a miscarriage of justice and an imposition on the states for Congress to repeat this for yet another 25 years. And I agree that it was pure politics that led this to happen, and I'm glad that the court struck it down. This is very similar to the desegregation context. In the desegregation context, extraordinary actions were taken against extraordinarily bad actors. The courts have always said that in enforcing the 14th Amendment, the goal of desegregation orders is to create a unitary system of education and to return governance to local decision makers as quickly as possible. That is essentially the same principle here. And a number of terms have been used to describe what's going on here. But basically, what this court's decision did was to transform a presumption of guilt into a presumption of innocence. And that 40 years after the Voting Rights Act was created is entirely appropriate. If Congress wants to finger jurisdictions for Section 5 preclearance responsibilities after this court's decision, it has the power to do so. And it doesn't have to itemize the jurisdictions. It simply has to come up with a formula that says that there's low voter turnout, or that a Section 2 lawsuit has been successful in the last 5 years, or something of that nature. But to hold a state guilty 40 years after the fact and to impose incredible impositions on it simply does incredible violence to our system. Four years ago, the U.S. Supreme Court, as David mentioned, looked at this issue, and I totally agree that it completely punted on this issue and basically rewrote the statute to avoid deciding the decision. And the court did say that there were serious problems with the Voting Rights Act. That decision, unless I misremember it, was unanimous. How it was that 4 justices suddenly decided that what they said 4 years ago wasn't true anymore is beyond me. Instead, Justice Ginsburg said, and I quote, "This law, quote, should elicit this court's unstinting approbation," end quote. If she's referring to the Voting Rights Act, I wholeheartedly agree, and I wish it a very, very long life. If she's referring to Section 4 of the Voting Rights Act, that is a very radical and anti-democratic statement to make.
Well, my comments will be somewhat limited. I'm going to probably limit them mostly to some history. In Nicholas versus Katzenbach, the Section 5 preclearance was upheld, and it was applied to the original, I think, 7 deep South states that had a history of evading federal voting rights laws by simply, they'd have a lawsuit, it might be the Justice Department, might be private, they'd lose, then they'd tinker with the law, there's a new law, there's a new statute, and they'd apply that. And that was a settled history of bad faith evasion of litigation, and there we were 90 years after the Civil War, after Reconstruction, and the sentiment was that 90 years is long enough to wait to implement the voting rights of black Americans. Now, the system that was adopted, the core of the statute was Section 2, which prohibits a racial discriminatory practice nationwide, but they had the formula that was intentionally drawn around those states. I mean, they made no secret. They didn't come up with a formula and it hit that way. They looked at those states and came up with a formula that would get those states. No secret about that. But they were the deep South states. And the justification was that, in effect, it took away the governmental authority of the state and local jurisdictions to make changes in election practices. And a couple of things really magnified that. It put the state in receivership as a practical matter, but the court said this is strong medicine and it's needed. It was the making of changes that was the evasion that evaded what otherwise the law that could be enforced on a case-by-case basis. This became a very, very powerful tool because no changes could be made without approval of the Justice Department. There's a mechanism to go to the court, but it is prohibitively expensive. It can only be filed in Washington, D.C. It takes years. You can't get it done in time for the next election. You spend a fortune, and it doesn't matter whether you win or not. So at least that was the perception. So the Justice Department was basically in the driver's seat on these changes. Another big thing that happened is the Supreme Court, by case interpretation, interpreted as voting practices to include private racial discrimination in voting. Later, the court, when it reenacted, adopted that, but basically, originally it was, does the state or the county or whatever Are they passing, is their action racially discriminatory? Then they went back to private voting discrimination, where the people, voters, would vote for or against a candidate because of racial discrimination. And that was held to be a voting practice. And therefore, when the state made changes, like you have to change every census for redistricting, you have to correct this voting practice of private racial discrimination in voting preferences. And that significantly expanded that as well. Now, by the way, what I'm telling you now, I'm taking it from the seminal work by Abigail Thernstrom in, I think, 1986 of her book of Whose Votes Count, that goes through in detail the history of the Voting Rights Act and application. What happened was this preclearance was such a powerful tool that Hispanic interests said, we want that too. I mean, that's great for the African, we want it too. So her account of the legislative history of the 1975 amendments is they wanted to get preclearance where areas where Hispanic voters were substantial. So they had to first come up with a discrimination. So they came up with the language discrimination, which is you only conducted your elections in English. Well, there was no law that required you to conduct your elections in other languages. So it was an ex post facto violation. Now, it may have been done in various places out of racial animus, but there was no history of, like there was in the Deep South, of using changes to evade. The legislative history, she says, was limited entirely to instances in the state of Texas. So they adopt the formula. That's what brought Arizona in, because Arizona has a large Hispanic population, and lots and lots of, and they defined it by a voting turnout in 1972. You didn't have a 50% voting turnout, and there's other, you're covered. So lots of states got brought in. Random counties got brought in around the country. So there wasn't this history, and when I say history, I mean repeated, bad faith, wrongful changes in laws for racial animus. This is one where the tail was there to wag the dog, and the dog that was desired was the preclearance. So fast forward, it's 40 years later. I personally think the accounts, if I can steal from Mark Twain, the accounts of the death of the Voting Rights are greatly exaggerated. When you look at a formula that was adopted 40 years ago, there's a lot to be said for the conclusion that it's not even rational to continue to apply it 40 years later. It wouldn't even pass the rational basis test. The Supreme Court, gave them their chance to fix it, and then they didn't for reasons that we can speculate on. So all it requires is some kind of a rational judgment that's connected with this point in time. So the core of it's there. Section 5 can be applied, and the court has required Congress to do that. Now, this preclearance, as the court said originally, it's strong medicine. It's really putting the state government out of its ability, exempting this from the normal political and governmental processes. And we have that in our history. Reconstruction. That Reconstruction existed because the Constitution isn't just defined in the text. It was settled on the battlefield in the Civil War. And the federal troops went down and occupied the southern states and reconstructed them until the election of 1876, in which the deal was cut to let the Republicans steal the presidency and end Reconstruction and take the federal troops out. So that was the beginning of the end of Reconstruction. So there is precedent here of use of the federal power to enforce the 15th Amendment, to end this racial discrimination. The question that seems to me to arise here is, what's the extent of that? Is that equivalent? Is it the same as the necessary and proper clause? Can Congress come in and basically oust state government to achieve anything that it could achieve under the necessary and proper clause? Because that's really never been endorsed by the court. Reconstruction was a result of rebellion and war and amendments that had to be enforced. So the answer isn't given there, but the history is that it is viewed as strong medicine, and it's still there to be, if an application formula is given that has some basis to it. So and the last round, why didn't Congress go in and fix this when the Supreme Court told them 4 years ago, hey, come on, you got to take another look at this? Of course, I don't know, but there are powerful political interests at play in this. There are interests on both the major political parties to get benefits out of this system. There are benefits to minority interests that are usually democratic interests. Maybe depends on what minority you're talking about, but certainly a majority. There are benefits to Republican and conservative interests in this as well. The Voting Rights Act results often in increasing minority populations and therefore increasing Democratic populations in districts. And traditionally Republicans think that's great. So both sides are getting something out of this. So it may be that is, I don't know, that there's a certain forces at play. I have no idea what happened in Congress. Now they can come up with a new formula that fits something modern, and we're back in business.
Okay, I can't contain myself. I just want to make just a couple of things. I want to suggest a different metaphor from the person who's given a 5-year jail sentence and kept in jail indefinitely. What if somebody commits a crime, a vicious, miserable, horrible, horrific crime, for over 100 years, and then is put on probation? The requirement of probation is that you check in periodically when you might be tempted to be a recidivist. This is, as I see it, the way the Voting Rights Act works. It's not perpetual, a perpetual sentence of imprisonment, but rather you have to visit your probation officer. The second thing, I just wonder what the administrative burden really actually is. I understand the injury to state sovereignty in sort of abstract terms that the preclearance requirement entails. But if you actually look at the evidence about the actual burden visited upon jurisdictions that have to seek preclearance, I just don't know what the there is. The state of Arizona sued to challenge the constitutionality of Section 4 and Section 5 in a 2011 case. I looked at the complaint. The state enumerates the misery it suffered under this horrific law, and it turns out that the state was able to come up with 2 instances where burdens were visited upon it that it didn't like. One was that the state wanted to usher through a change to its voting laws in a particularly expeditious fashion, and the Justice Department took 49 days to act on the request that they pre-clear it in a quick manner. The other one was something similar. I found statistics suggesting that it costs the jurisdiction on average $500 in employee time and money to seek preclearance of any particular change to a law affecting voting. The third thing to say is that the Chief Justice's principle of equal sovereignty simply lacks any sort of political theory behind it. I thought that the United States Congress is supposed to include safeguards, political safeguards of federalism. Now, perhaps the politics of voting rights are such that the political safeguards malfunction. But it is true that the statute in 2006 passed 98-0 in the Senate, and by a super majority in the House. I wonder what the political theory of equal sovereignty is, why the court needs to wield this potent weapon when there are in theory, at least some sort of political ways to protect federalism concerns. In 2009, when the court considered the Namudno decision, the Attorney General of Arizona, as well as other attorneys general around in states that were covered by the formula, submitted an amicus brief actually arguing that the statute be upheld. The fact that Arizona in 2011 then challenged the statute, to my mind, suggests less a concern about Arizona's sovereignty than the change of political membership of the Attorney General. And the final thing to say, it was indeed true that Namudno was a 9-0 decision. But I think it's a decision. It's a decision that's doubly cynical. It's cynical because I'm quite convinced that the Chief Justice held a gun to the head of the liberal justices and said, if you do not vote with me on my statutory interpretation argument, I will rally my troops and we will invalidate the Voting Rights Act. And so the liberal justices, my guess is that they bought the Voting Rights Act, or at least Section 4 and Section 5, 4 more years. And then the suggestion that this is that Mundo, that the court offered Congress the chance to get its house in order. Well, Chief Justice John Roberts is every year when I do this, I'm impressed, if by nothing else, I'm impressed by the savviness with which he operates. Surely he knows that Congress never would respond to his invitation to change the law. And so, I think that that he planted a time bomb in his 2009 decision. He held the liberal justices hostage to get them to go along, and he was able to let that bomb go off 4 years later. I don't want to have the last word, but I will. So we have. Oh, sorry. No,
go ahead.
We have. Clint has suggested that since we have 20 minutes left, that we open it up to question and answer. You all have been sitting here so nicely listening to us. We would love to hear from you.
All the talk about how many years go by between the passage of the act and how something may be an anachronism, was there either any consideration or any place for consideration that 7 months before the decision was rendered in the Shelby County case, voters primarily in black districts in Miami and others in Florida had to stand in line for 8 hours to exercise the franchise?
I don't know.
Good question.
Good question.
I don't have an answer.
Let me throw in another thing, and that, again, this is really going into deep history. In the Constitutional Convention, they addressed the issue exactly of how to deal with conflict between state government and the federal government, and there was a proposal to have Congress directly approve or disapprove state statutes. That's not what was adopted. Instead, the Supremacy Clause was adopted, where federal law would prevail over state law, and the mechanism, that was the mechanism. So the idea that the federal government simply will take over the state government is ahistorical as to the Constitutional Convention. Now, as I said before, the Civil War is a fact of constitutional law, and it has settled a lot of things. And one is that the federal government can do really, really vigorous things, including sending the troops down and occupying, taking over the state government to bring them in compliance with our notion of what the Constitution would provide. But in general, we deal with, that's how federalism works, that the Supremacy Clause in government enforcement or private enforcement is the usual mechanism. The question is, what I think is, what should be the criteria for casting that aside and basically having the federal government take over? And the answer is, it seems very clearly to have been justified in the original book at Section 5 in 1965. 90 years of evasion, my gosh, since the troops left. But the harder question to me is, well, at what is the dividing line? Is there any dividing line? Is it any time that we can find issues of violation, we can just go in and take over state government again? As I said, I don't think the Supreme Court has ever endorsed that.
Yeah, but it has noted that it's not just that the Civil War amendments come in and change the game. They fundamentally alter the relationship between the federal government and the states on certain key issues, one of which is voting, right? And they talk specifically in their court opinions that bear this out, that voting is different. The franchise is different. It's not like desegregation. Like, we don't have a right to education that is articulated in the federal Constitution. We do have a right to vote. And that's why voting is different. And the fact that voting is different and important and sort of the core value that undergirds an entire system of democratic governance and participation means that that is one of the limited places where the federal government does get to take priority.
Why not have the federal government just have free clearance for the whole country? It's essentially random the way it applied under Section 4 after 40 years. Why not just apply it to everybody?
Well,
And that would eliminate the concern about lack of equality among states. Every state would be treated equally. No state can run this. The Justice Department runs it.
No one is questioning the constitutionality of Section 2 of the Voting Rights Act. And in fact, no one, if a current formula is put in place, Section 5 remains as well. But the Section 5 goes far beyond voting. It goes to things that are very, very much traditional state functions that have the most attenuated effect. For example, every annexation, and you know, for everyone who lives in Arizona knows how many annexations we do every year, and it's not just cities, it's utility districts and that fire districts and so forth, water districts. Every single one of those has to be pre-cleared. The change of every voting location has to be pre-cleared, and so you're getting into the minutia of state government. And getting back to David's point before, what if you had someone on probation? Well, probation is supposed to end at some point too, and one element he talked about recidivism. One element in an updated formula could be recidivism. If you have an actor that continues to engage in these types of illegal conduct, then keep them in the process. But by and large, many of these entities, for gosh sakes, couldn't discriminate if they wanted to. So why are they still bound by findings of 40 years ago, in the case of Arizona, flimsy findings that probably should never have warranted that sort of extraordinary.
Let me add another bit of history. The original text of the statute, and by the way, I personally, as a young lawyer, I did all the preclearance requests from 1976 to 82 for the Salt River Project. Every time we moved a polling place, we had to do it, and we couldn't do it for $500 back then. I'm sure you can't do it now. But the original text defined the jurisdictions that were covered, and it defined them as the jurisdictions that registered to vote. In Arizona, that's the county. That would not have applied to cities, school districts, irrigation districts, anything else. And then in the case of, I think, Sheffield County, the Supreme Court in the late 80s said, well, you know, this preclearance is a great idea. Why would we want to limit it at just counties? So by sheer force of judicial creativity, they expanded it to the levels of jurisdictions that don't have the practical ability to discriminate. Maybe, of course, anybody could discriminate, but the quantum would be so attenuated. And that was then written in the statute since then.
So I want to just make a point about Clint's point with regard to the minutia. We can call it minutia, but this minutia matters. Like, it makes a difference if you decide to close a DMV that registers voters if it's the only DMV in a predominantly minority district or predominantly minority neighborhood, and that's the sole place that individuals have to register to vote. That makes it relevant to the exercise of the franchise. It makes a difference if you are annexing land for the purpose of creating a majority white district that you can dilute the votes of black voters.
Well,
and I'm not saying that
true.
everyone is doing this, but if it is the case that some people are doing it, why then shouldn't we subject those decisions to preclearance so that we can ferret or smoke out the ones that are truly invidious?
See, the response, what I think the burden ought not to be on the jurisdiction to prove innocence. Rather, the burden should be on the prosecutor to prove guilt. And the Justice Department, having worked in the Civil Rights Division, the voting rights section is by far the largest section of the Civil Rights Division. It has lots of attorneys. And if you find the rare instance, you know, the vast majority of preclearance requests are approved, which suggests that the vast majority of these changes are in fact not discriminatory, and yet it is a may I please sort of system that's being imposed. Why not, when you have, I totally agree that closing a particular DMV location could be discriminatory. I think that the Department of Justice or the NAACP Legal Defense Fund or whatever has the resources in those rare instances to come in and nail them they should. And as part of the remedy, impose on that entity a preclearance requirement. I have no problem with that at all, but imposing on the vast majority of non-rule breakers a presumption of guilt is I think, unconstitutional and profoundly un-American.
I think all the members of the panel talked a little bit about the notion that the court punts certain ideas or doesn't only hits on outliers or doesn't want to face backlashes. And I think we all agree from a sort of political science side that certainly happens. But is that a legitimate function of the court legally? I mean, if there is a right to same-sex marriage, then damn it, there is a right, and stop freaking punting on it. Give it to us today because it's our right today. Should the court be doing this? I mean, it was right or wrong in Roe v. Wade and has nothing to do with the reaction of the public to that decision. That seems to me fundamentally lawless rather than being what we're supposed to be about with the Supreme Court, which is all about the law.
Let me dodge the question. I'm going to punt. No, but what I'd like to do, I've thought a lot about this question the last couple of weeks as I prepared for this afternoon's exercises. And the way that I've thought about it is by contrasting what I think are some magnificent, well, at least in the Shelby County decision, a magnificent opinion by Judge Bates, the district judge, and a untheorized, empirically barren decision by the Supreme Court. Judge Bates spends 55 pages going meticulously through the legislative record that Congress compiled. Judge Bates applies the congruent proportional test from City of Bernie, which you're supposed to do when analyzing whether prophylactic legislation by Congress does in fact protect constitutional rights. He goes through the doctrine that the court has laid out for federal judges to abide by. It's a magnificent opinion. It makes sense. It's clear. It's logical. And then you go to the Supreme Court's decision, and it's like an essay on what someone might like the law to be without any actual rigorous examination of the background precedent or the underlying legislative record. But I've been thinking about this and wondering, how can the court get away with this when there's a model of wonderful judging right there that it has to read? And my only thought is that there's a very different institutional role for the Supreme Court, and that the fact is the Supreme Court has to act in ways that are not really pure law. That it's charting a course that's part law and part politics. And if that means that sometimes people's legal rights don't get vindicated, then that's just the institutional job the court has to do.
I agree emphatically, Mr. Aguilar, with the premise of your question, and that is the whole point of having an independent judiciary vested with lifetime tenure. And it really bugs me, even if the decision goes the wrong way, it bugs me when not only courts duck questions, but when they create really damaging doctrines as a byproduct of that.
Let me jump in and defend the court a little. Just a little. I think if you are a person who is in a situation where your rights are at stake, the punt hurts, obviously. But the Supreme Court's position in the whole constitutional scheme of things is really kind of precarious. The court depends on the public for its legitimacy. It depends on the public looking at it and recognizing it as a neutral arbiter of these issues for its legitimacy. It doesn't have an army. It doesn't control the purse. It cannot send the National Guard. I mean, look at Brown. It took forever for Brown to be implemented. It took Eisenhower sending the National Guard to Little Rock to desegregate the South. The court doesn't have anything but its own legitimacy, and it depends on the public looking at it and understanding it to be making legitimate decisions for that legitimacy. I mean, it's sort of circular and tautological, but that's where it is. So it does punt. It is cognizant of public opinion, whether it adverts to it or not. I don't see how it couldn't be. We might bemoan it, but I think it's trying to sort of make decisions that the public understands as being legitimate. I think it's one of the reasons you see that sort of consensus movement in a lot of its decision-making, not all of it, but in some of it. And especially on these questions of social justice, these sort of culture questions, as Justice Scalia might say, that sort of go to the heart of the deep divisions that riven the country.
Well, I agree with that, and I think the answer to the point that was raised earlier about why people have not objected to the DOMA decision and gone out to the streets to riot and that sort of thing is the same answer to the question of why they didn't do it in Bush versus Gore, which I consider a really horrendous decision, even though I was momentarily happy with the consequences. And but the court has built up a tremendous bank of legitimacy in our society, and sometimes it draws upon that bank account. But fortunately, it has not, at least of late, drawn upon it so much that the legitimacy of the court is drawn into question, and I am really glad for that. Having said that, and despite agreeing with the vast majority of the Roberts Court decisions, and thankfully with Justice Kennedy often playing the swing vote, from what I know of Chief Justice Roberts, I really think that he is too political by half. And some of the theories, that like almost no one predicted how the Obamacare decision would come out. There's a good reason for that. It's not a very cogent decision the way the court did. The theory about the Northwest Austin case, if that's true, that disturbs me, even though I liked that decision a great deal. And I do worry that Chief Justice Roberts would have been better suited to be an incredible deal-making senator than the guardian of the rule of law.
Your comment about why the court has to avoid problems, and I think Professor Murray put her hand on it. I think if you look back at history, the Supreme Court is rarely ahead of public opinion. Can't even think of any time right now. Even Brown versus Board of Education, there were regional issues there, but they were with national consensus. So Supreme Court, sometimes they do, sometimes they make, Dred Scott, they were way off whack because 30% of the population lived in the southern states. They had 5 of the 9 justices on the Supreme Court, and so the slave states controlled the Supreme Court. They were out of touch with public opinion then. But most of the time, the Supreme Court, not always, they got whacked out on economic due process, back when they decided your favorite case. But when they struck down the income tax, oh my gosh, so they were out of touch then. But most of the time, they're just following public opinion. And I think you're right, they deal with outliers. There's some areas like the 8th Amendment cruel and unusual clause. The express doctrine is evolving. So what is cruel and unusual is something that evolves. But other times, they just do it silently.
This is my question if it's naive. You're talking about the court opinion of the public, they're being controlled by the public's opinion. It's my impression that the higher you get in government, the more removed you are from public opinion. You actually don't know what's going on. And unless they're using it from the feedback of their own regional area. And it's my understanding that most of the Supreme Court are from New York. So if that's the case, we have, I think there's only 1 or 2 members of the court are not from New York. So theoretically, they would be functioning on this regional attitude that they're getting feedback from their own area when they are exposed to the public, when they go home to see their families or whatever.
Well,
so where are they getting the metrics for their...
In the 19th century, the tradition was that there was 1 justice from each circuit. Now there's 1 justice from each borough.
I don't think we ought to make the mistake that Mr. Dooley made, saying that the Supreme Court follows the election And I don't think that's what this panel is saying. I think the court has to follow the sweep of history, not the daily votes on specific issues. And that's what the court does. Frequently, I had the experience of being very upset when they would deny cert on a case that I had thought they ought to decide. But the reason frequently that they did that was that the time was not right. That the sweep of history, the general movement of the country's beliefs had not moved to a point where it would be possible for the public to accept the proposition that the court laid down. Brown versus the Board of Education was a perfect example of that. The country was, in general, ready for that. The South wasn't, but it was never going to be. But there was a general sweep of the tides of history that the court waited for to come to the appropriate moment when it could decide that case. And Thurgood Marshall and Charles Houston led up to that in a perfect way. They started off with elementary schools, then they moved up to high schools, then they moved up to junior colleges, then they moved up to colleges, and finally we got Brown versus Board of Education. And they built up the feeling in the country that it was time to stop this business of racial segregation. And so the court doesn't follow the daily accounts. The only case I can think of where I had the strong feeling that politics, in terms of daily politics, was Bush v. Gore. There may be others, but there may be others with respect to particular justices, but not the court as a whole. So the court doesn't follow the daily politics.
One last question.
One last question.
I just wanted to make one observation as an interpreter who's trained in South Africa and was working in
He was on a step with
when South Africa got a constitutional court, a Supreme Court. And the role of the Supreme Court there is completely the antithesis of what you're describing here. It's absolutely not meant to be a reflection of public opinion. That's the job of the legislature. That's the job of the legislature.